Good morning, good morning, good morning. It's Tuesday. It's time for Coffee and Cursey Words. We have a new lawsuit to cover today. Are you ready for something new? It's like, can we just do something new? Yes. Today we're just going to do something new. I'm going to continue to mess with my mic because, your girl was running a little late. She might have overslept a little bit because I'm sick. And my husband totally helped. He was like, "Let me take the kids to school this morning." And I was like, "Okay, well, Ah, we're gonna be on time. No, nope. So let me know what you're drinking, where you're coming in from. I got coffee. The first sip's always the best. And yeah, today we're going through what's happening today in court with Jen Shah, what's going on with the Duggar reply. We're just going through the reply. I will do a quick road so far of what has happened with the post trial motions. But if you want that breakdown, you're gonna have to go to that video. There's a playlist. There's a playlist you can go because we went through all of that stuff. And then we're going to get into the new Kristin Cavallari lawsuit. It has pictures. You know how I feel about a lawsuit with pictures. I love it so much. I love it so much. So we are going to just jump into it. I'm going to say hi to everybody. I know there's a lot going on in the world. And with that, I've shared resources on Instagram. I'll share Ooh, I can't talk when I'm going so fast. I'll share more resources on Instagram and on Twitter if you guys follow me there. For Aid with Ukraine, for news sources that I trust when I'm trying to parse what is fact and what is not fact. News sources that are willing to update things and be like, "Oh, that was that, but now it's this." Because when situations move fast, like me this morning, it is you need a news source that is willing to update and change and is willing to say, "Oh yeah, we said this, but it's now this." And that's what I look for in news sources. So what we are going to do today is just get into the pop culture stuff, even though the world is kind of crazy. We're gonna do the things. So I should just roll the intro. I still sound like, you know, this, but it's clearing up a little bit. It's Mucinex has helped. I mean, but we're still under the weather, and so I'm going to do my best. I'm sorry that I sound terrible. So, all right, let us go. I would rather sound terrible than not be live. So, if you knew me in law school, this is what I sounded like half the time. I had sinus infections like, I don't know, once a quarter. I felt like they were a regular part of my life. So, let's just jump into let's get into the things. Are you ready to talk about pop culture? Are you excited for something new? I'm excited for something new. Like let's not break into songs from Encanto that I won't do justice to, and let's roll the intro and let's get into it.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
Marissa, thank you for bringing this up. I have not seen that there was a settlement with Ventura County, but I will go and pull that up in that wrongful death suit. I covered it ages ago. It's a very sad suit. It's a very sad situation. It was hard. It was very hard to cover. So I will go look at the settlement and then I can break that down on Friday. I'm going to make a note. I'm literally making a note right now. Because I can't talk. Why can't I talk and type today? Normally I can, but my brain is not. We're not 100, so talking about one thing and typing another thing is hard when we're not at 100. But um, I will absolutely look at that and then bring that up on Friday for sure because I had not seen that. So with that, we've got lots to talk about. I am not even doing quick bits. My goal for today is one, to not devolve into a ball of phlegm. Two, to get to plenty of questions because we went so long on Friday, and to give a good breakdown of both the Duggar Reply and the Cavallari suit, and both of those are over 20 pages, and then do a quick Jen Shah. I also want to remind you, it is the beginning of March. Happy March. I mean, it was like yesterday was so cold here in Middle Tennessee. I mean, not so cold, but it was pretty cold. Cold in Middle Tennessee. And today it's like, hello, sunshine. Hello, my baby. Hello, my darling. It's like it's March 1st and the sun is out and all the like froggies are croaking and the birds are singing and the squirrels are running around. It feels like spring is on the way. I know this is probably fake spring number 4, kind of like Mambo number 5, and we will probably get another cold snap. I have not looked at the weather for the rest of the week because I spent the weekend in bed trying to play Pokemon in my car a little bit detached from humans because I didn't want to get anyone sick. But I then spent some of Pokemon in my car and then and then and then in bed. So it was, productive, but it was very cold over the weekend. And now it's like 50 degrees and lovely. So hopefully the ick will be gone and I will get back to the Purple Beast, my new treadmill. I was like, I felt so good. I was like, we're doing this. We've got like a flow. We've done this like 3 days in a row. And then and then I got sick and I was like, well, there we go. All right, we're just gonna lay in bed and not doom scroll the news and read books and play Pokemon from home and watch Twilight movies. Like literally that's what I did. But my 13-year-old, almost 14-year-old, has been binging The Office, so we've gotten to do a little bit of that too. So this weekend I was playing Pokemon Go. No, it is not COVID. I've taken multiple COVID tests. I think it is quick weather changes that my sinuses can't handle. I get sinus stuff. I am very prone to sinusy things. So I was playing Pokemon Go, but there was a new Pokemon announced that I'm very excited about. There's probably going to be an Apple announcement. Actually, that should have just happened. Now, actually, invites should have gone out. Let me check Twitter. Invites should have gone out for the new Apple event. So that should be happening. And I don't know. So we should get an Apple event. It looks like on March 8th. I'm very excited about that. This is not your source for tech news, but I did start out wanting to do TechTubey things. TechTube is like one of my favorite communities on the internet, and I love it. So there should be soon Apple invites going out, and we will see those on Twitter. But we'll talk about those at the end. And yeah, all right. We should talk about the topics that you came here for, probably. It's Tuesday morning. It's like 1,500 of us. It's just friends here. It's just friends here. It's just friends. This is like I love Tuesday mornings when we get to just chill and chat and the chat's not moving so fast. My humidifier, Miss Opinionated, is on like 10 over there. Hopefully you don't hear it in the background. It is on a million. The Lone Wanderer. Hi, Emily. You always make my workdays so lovely. They go by so quickly when you're live. Thank you. Well, you're welcome. Dawn, thank you for asking. The updates on Peter are the updates that he shared on Twitter. I retweeted those and he shared those. He is taking time off the internet to rest and heal and is doing that. So other than what he has shared publicly, I don't have any other updates to share. But he shared the extent of his injuries from that car accident. So it is going to be a long recovery. So let us move on to what are we talking about first? I tagged things in the description of the photo and then the description of the photo. In the look, so much here. We're going to do a quick we're going to talk about social media and then we'll swoop into topics. Did you guys see that TikTok is extending videos to 10 minutes? Here's the things that happened yesterday. Like TikTok is extending videos to 10 minutes. So all the short form YouTube creators are now, like, not me, but all the short form YouTube creators are going to have a crisis of where they create content. YouTube pays better, but TikTok is good for discoverability. And so putting content on TikTok up to 10 minutes, which is kind of nice because I could actually break something down in 10 minutes if I tried really hard. Like I would have to try really, really hard. Because it would take effort to do things in 10 minutes. But Instagram also just changed their payout format, and they had been putting ads on like live videos and live streams, and they are changing that completely and now like going all in on reels. So it's really interesting to watch like Instagram and TikTok kind of go back and forth with what they're trying to do, because again, TikTok's way better for discoverability, but Instagram is starting to pay and might be paying better for reels, but YouTube still for video content is at the top of the game for now. We'll see what happens. We'll see what happens, but I really do enjoy scrolling on TikTok, but I feel like you're at the mercy of the TikTok algorithm. I feel like it's not as searchable. So I like Instagram a lot. So it just depends. All right. Let us get into what's going on with Jen Shah. I think that's what I said we were going to do first today, because there's stuff going on in court. I'm going to pull up the 3 documents, and then we're going to go over what the court said, we're going to do a little bit of background. So you guys are going to get like the full tea, and then we're going to move into Duggar, and then we'll do the new and a little bit lighter Kristin Cavallari. So we're going to do like a shit sandwich. We're going to sandwich the fun pop culture stuff around the Duggar stuff. We're just going to make it work that way. Because that's how I want to do it. So let us go and swoop and talk it's only like 11 minutes. Oh, I should say it's the beginning of the month. I digressed. I started talking about the weather and my sinuses. It's the beginning of the month, which means if you are not a member, by the way, you do not have to be. This content stays free for you, ad supported and sponsor supported, which is fantastic. If you would like a deeper dive with content and the I Have Thoughts podcast, lawnerdsunite.com is where you can find that all on Patreon. If you are a diehard YouTuber and you want to have the icon and all of that, you can do the YouTube membership. There are things that are different about each membership. If I tried to price the lowest tier of both, so if you wanted to do both, it would not be exorbitant. So if you would like to do that, you can. Because it is the beginning of the month, we will be having a members only live stream next week. And the members only live stream is always a lot of fun. We do content that doesn't always fit on this. Last month, we did a breakdown of Tasha K's statement after trial. So it's that kind of things. We'll be talking a little bit about everything that's fallen down after the Rust lawsuits and Helena Hutchins' husband speaking publicly for the first time. That's also going to be an I Have Thoughts podcast episode up on Patreon. So it's a great time at the beginning of the month. If it's something you've been wanting to do that you can join there. And it's also a place where you guys as law nerds, I invite you to connect. I post up topics so we can have threaded conversations that is behind a wall and no one else sees it. It's just us, which is what I like better than maybe a Facebook group or some other options for us to connect. It is threaded to the people who choose to be there and kind of go deeper and have those conversations, because this is a very, very supportive community. And that is what I wanted to build. I wanted to build this community. So it was a wonderful and supportive place. Sister Babylon, isn't Patreon fun? I know. I love it. I love it. I love it. And I do get into the DMs at least like once a week. And Paige, to become a YouTube member, depending on what device you're on, there is a join button to join the YouTube memberships. I would join the Law Nerd tier. The others are phasing out. And that tier gets you the members only live streams and the icons and all that stuff. So you can do that here. If you are on certain Apple devices, you can't do it unless you're on desktop. So it just depends. Sometimes that is an Apple-y thing because it's a subscription that you're paying for through Google. And so Apple doesn't always pass it through. Jay Thompson, I know YouTube has been cranky at me. I actually talked to my YouTube. It's just the content, especially the Prince Andrew content, is not something that the YouTube algorithm loves. And it's okay. When the channel has its ups and downs, our community is still amazing. So it's fine. But yes, we are very close to 200K and that's super exciting. Let us swoop to Shah. I just wanted to let you guys know this is those are the things that are available to you should you choose to do those. If you want to do those to you, for you, to you, if you want to do those things to yourself. you know we're not feeling good when the words are already this hard. But with that, at the beginning of the month, I always try to remember because I don't want people to be like, I didn't know I could do members only live streams. Yep, they're a lot of fun. And and um we will be adding in the benefit of doing behind the scenes live stream recordings on occasion. So there will be extra bonuses to being members. You will have access to behind the scenes recordings of the podcasts. So that is something that I will be trying to do a couple times a month as well, to just bring, for those of you who are like, how can we have more content? I'm trying to find ways that we can just have more content. So with that, gosh, this weekend was hard. This weekend was hard, and I still just don't feel good. But I'm very excited to talk about what's going on with Jen Shah, because I'm looking forward to giving you guys kind of the deeper dive than I could give on the posts on social media, because of course posts on social media are short and to the point, and it's like the antithesis of everything else that I do. Which is not short and to the point. So at like 16 minutes, let's go ahead and jump in. Replay crew. Love you. Timestamps will be down below at the end of the stream. I'm going to swoop. We're going to talk about Jen, the Shah of it all. I don't know if you guys are watching Real Housewives of Salt Lake City. This doesn't really matter. To follow this Jen Shah case, the Real Housewives of Salt Lake City is context, but it's not needed. There are things she said on the show that I bring up here because I think they can come into play, especially when it comes to like the motions in Lemonade, where it was, hey, we don't want any clips from the Bravo show to wind up in trial. We want to keep those out. There could be Franken edits. We went through all those motions. They're in the Jen Shah playlist here on the channel. But what happened in January, and let me pull up Jen Shah's attorney's letter. What happened in January is that Jen Shah's lawyer, and this is super common, so if you guys want like the nuts and bolts of how like criminal trials work, I think covering all of these things leading up to trial give you a good idea of what at least federal practice looks like. In state, a lot of this doesn't happen in writing. It just happens in court orally, but it still happens. And this is like the behind the scenes before you get to trial. It's like the behind the headlines, if you will, of these cases. So of course, my screen sharing is turned on. No, it's not. It's not at all. Let's pull up Jen Shah's lawyer's letter to the court from January, because this gives us the context we need to where we're at now. January 14th, 2022. Dear Judge Stein, as the court is aware, we represent Jennifer Shah in the above referenced matter, which is set for trial on March 22, 2022. Ms. Shah does not seek an adjournment of this date. We don't seek to postpone it. Your Honor, we're not seeking to postpone it. We're not seeking to postpone it. Rather, for the reasons explained below, I submit this letter to inquire about the status. First, yesterday, undersigned counsel was offered a firm trial date of March 14th in another criminal case in this district, and must inform the other judge, Judge Rakoff, by Tuesday, January 18th, of whether she can begin that trial on March 14th. This is something that happens frequently. Attorneys have multiple trials ready to go that need to go to trial. This has gotten really bad since the panini, as trials have gotten pushed, courtrooms have gotten bumped. There's not been enough space. It has been a real problem. But she's offered a firm date, like we are starting on this day for March 14th in another trial. What she's saying to the judge is, I need to tell the judge what is happening in this case. For those of you that were in the member live, when I told the story about two judges fighting over a DA to go to trial, this becomes a real thing where judges are like, no, you need to be in trial in my courtroom, versus no, you can't be in trial in that courtroom. Like, just the lack of attorneys and courtrooms trying to move forward. It's a whole thing. I might have to tell that story again. It's been a while, but not today. So the attorney is saying that they promised the other judge that they would immediately inquire. And they say, Your Honor, previously informed the parties that our trial is the third case on the trial calendar for March 22nd. That means on March 22nd, there are 3 trials set, all at the same day, set to start that day. So the judge is going to call a jury panel, and that jury panel might get case 1, 2, or 3. It says, I have confirmed with the government and have learned that the 2 cases ahead of ours are both criminal cases, and that as of this date, that those cases are likely to proceed to trial. If the March 22nd date would not be our actual trial date, we respectfully request that the court schedule a status conference soon to pick a new trial date, as I understand that the executive committee will begin assigning trial dates for the second quarter of 2022 in mid-February. So they're saying, look, if our case gets bumped, the trials are already getting scheduled by the committee that is scheduling trials to try to make the trials go forward with the courtrooms that they have for the second quarter of 2022 already. So if those are already scheduled in February, we need a new date before we get bumped behind all of those trials. Therefore, Shah is concerned that if we are unable to begin trial on March 22nd and do not request a new date by mid-February, we would not get a trial date until the third quarter of 2022, which is actually possible. Shah seeks the earliest possible trial date. I want to prove my innocence now, Your Honor. For those reasons, I respectfully request the court confer with the executive committee and inform the parties whether this trial will be able to commence March 22nd. This was back in January, and they wanted to let the other judge know. I have not pulled that case to see what that date is, but let's look at the judge's response to this. So the judge responded, pardon? The judge responded on January 18th. So that letter was January 14th. So the judge responded 4 days later. I am not persuaded. Did the judge wait until it was like, I promised this other judge I would respond by this date? Or was the judge busy? Or were they not in chambers? I don't know. But they responded 4 days later. And this judge is normally pretty quick to respond and said the court is in receipt of the letter dated January 14th, in which she, quote, inquires about the status of the March 22nd trial date and accurately states the current status. As of today, this action is third in line for a COVID-19 compliant courtroom on March 22, 2022. This court is unaware of the status of the 2 cases that have precedence on that date because the court wouldn't know. The attorneys would know, but the U.S. attorneys should be able to say what's going on in those cases, because the attorneys can ask each other, is this going to trial? And as you're in January, February, you will generally know if you're going to trial or not. The other defendants in this case have all pled. It's just Jen Shah. So the AUSAs know if they're having proffer conversations with someone or not. They are aware. So this is not a hard conversation to have. If those cases resolve before March 22nd, this action shall proceed to trial on March 22nd. If those cases are not resolved before March 22nd, the court will set this action down for trial the second quarter of 2022. I am sorry, Ms. Shah. It could be lunch meat. It could be peaches. We just don't know. As set forth in the court's order dated December 2, 2021, the parties are to be prepared to commence trial on March 22, 2022 at 9:30 a.m. Be ready, bitches. Be ready for trial. And that's where we left off with trial scheduling. Then we went into the motions in limine and the proffers for jury questions. And we looked at that, and Jen Shah wanted to ask about, converting religions and all this other stuff. And the government was like, we're not getting into any of this in jury questionnaires. Then yesterday, the court orders, yesterday afternoon, the court's like, yo, tomorrow we need to chat. There will be a conference Tuesday, March 1st at 2:30 p.m. to discuss trial scheduling. This is a quick turnaround for a hearing. This is be here tomorrow at 2:30. This is fast to schedule a hearing, which means the court is aware of something. Here's what I'm saying. If this is a be ready for trial conference, The courts already had that conversation. The last court order on this from from January 18th said, be ready for trial March 22nd. There is no reason to have a trial scheduling conference today, March 1st, if this isn't going to go out further, because the court made it clear in January, be ready for trial. So I'm thinking that this is the court knowing that the other two trials are likely to proceed and this is going to need to bump, and trying to pick a court date quickly. So trying to pick a new trial date quickly. That is my supposition. That is my guess about what's happening. Because based on the court's previous order, where the court said, be ready for trial March 22nd. Why is a new trial scheduling conference needed? There wouldn't be one unless something changed. The only thing that's going to change is that this is going to get bumped back later. That's why I think this trial is likely to get bumped into Q2 or Q3. Watch it get bumped right into the middle of the freaking summer. Q2 or Q3 of 2022. They're lucky they're not going out till 2023. Things in LA are getting scheduled into 2023 and sometimes early 2024 in civil cases. So criminal cases take priority and tend to go faster, but scheduling dates are backed up everywhere. So then Jen Shah's attorneys said, as the court is aware, we represent Jen Shah. Given the recent scheduling of the conference tomorrow at 2:30 p.m., we respectfully submit this letter requesting Jen Shah be excused from appearing in person as she resides in Utah. And the court approved that this morning to excuse the defendant from today's conference. Though the defendant could appear by phone call, but it's just a status scheduling. And what the fuck else does Jen Shah have to do? I mean, really, Jen wants to go to trial. It's not like she's pending anything else other than scheduling or shooting season 3 of Real Housewives. There isn't anything else she has to do. Speaking of scheduling, twice now. Speaking of season 3 of Real Housewives, did you notice in all of you that watched, go ahead and put a snowflake or a 1 in the chat or in the comments if you're watching Replay Crew. For all of you that watched the first part of the reunion, did you notice it was filmed in Los Angeles? It was filmed in Los Angeles. Here's what I will say about that. Jen Shah's pretrial orders indicate that she needs to be in Utah or in New York for trial. The reunion was scheduled in LA. Now, I've said this with the Duggar case, and I'm going to say this with this case. She is out on bond. She will be allowed to travel if it is approved, and traveling for work is generally something that would, or the type of thing that would be approved. So if she knew it was going to record in LA, she can get approval from pretrial services and the court and the AUSA to travel to LA for work. So I saw a lot of questions in my DMs about this because it said at the beginning of the reunion, like Los Angeles, and had the date, and they were all pulling up. So that is why I thought I would address it. But you can request from the court to travel, and work is one of the things the court might let her travel for. 1, there's an interest in her paying her attorneys. 2, there's an interest in her still having her job if she's going to make restitution down the road. And 3, she is on bond and she's going to be on film. It's not as if they're worried about where she might go. They would generally have to submit a ton of information. Sometimes somebody might go to LA and check in on her from the local probation. I call it probation because I was a state attorney. From the local pretrial services office, she might have to go check in LA with pretrial services and be like, yo, I'm actually in LA. I'm not in Cancun. But I've also noticed that at the beginning of season 3 for Real Housewives of Salt Lake City, they were filming in Arizona. And the same thing, she can get approval to go do these things for filming. So don't worry, Up Mayo. I'm not going to talk about what happened at the reunion. We're just going to talk about what is likely the case with her traveling. I can't imagine a world where Jen Shah's attorneys allow her to travel to LA to film a reunion where it says it's in LA without clearing it with the court, because the AUSAs would be like, I'm sorry. This is filmed in LA. You went to LA. You didn't give us heads up. And then they would revoke her pretrial status and put her into custody. And I don't think she wants to risk that because there's no reason to. Jamila asked if she's wearing an ankle monitor. She was not on monitoring the way that Josh Duggar was. So no, she is not on a monitor for that. She has to check in. She has to pay the bond and all of that stuff, but she does not have to do anything else. So with the recent trips, Emma, the trips in season 3, they stayed within Utah. I think it's because it was so early on in the case. It would have been very hard to get that approval because the first trip was going on when she got arrested and the next one happened very soon after that. So it would have been difficult. She's had more time now to get those approvals through her attorney. Her attorney might have also said it is too soon to start asking for favors, but you do have to work. So that is my guess as to what's going on there, just based on my experience and what I'm seeing in court. That is our best speculation. Here's the facts. Here's what I think they mean. That's what we do here. So now we're going to get into the Duggar stuff. Jess Matz, congratulations. I know you are not alone in this community. Many have been through chemo. So congratulations, congratulations, congratulations. Cheers. The Law Nerds will all celebrate with you. All right, let us get to this is a first look. I have not read Duggar's reply yet, so we'll see how we feel about it before we get to Cavallari's lawsuit. Let me pull it up real quick. Let me timestamp it. But that's all with Jen Shah. If you follow me on social, not a plug because my Instagram's almost at 40,000, but kind of a plug because my Instagram's almost at 40,000. If you are not following me over on the IG or the Twitter, it's at the Emily D. Baker. And I will update today when there's a minute order from the court saying what's going on. So let's get into this reply and see what his attorneys had to say. Because swoop, Emily, swoop. You want to talk about it? Just swoop. Swoop. So where we're at with the Josh Duggar case, a brief road so far. Josh Duggar was arrested. He went to trial. He was convicted. His attorneys made post-trial motions for an acquittal, like a judgment notwithstanding a verdict, acquittal, or in the alternative, a new trial, or in the alternative, at least please, pretty please dismiss count 2, which is a lesser included and is going to be dismissed anyway. So they're going to get a win on that because it was going to happen literally as a matter of law. The attorneys in the post-trial motion for new trial, motion for acquittal, argued a lot of things. The government came back with adorable, here's more facts. And the government gave us more information about this case than we ever wanted or needed to know. And again, I will link that exact video down below in the description, and it's in the Duggar playlist. It's the most recent one, breaking down those motions. The defense asked for a extension to file their reply to the government's opposition. The government's opposition included awful things like the names of the types of files that he was looking at of the illicit images. And I am going to try to moderate my language to play to the YouTube game because, again, this is a space for education. We don't need to over sensationalize it. Y'all know what it is. It's bleh. We all know what it is. So we don't need to hyperfixate, I guess, on all of those disgusting details because it was a lot. But what we do need to do is talk about what the reply is from the defense, because again, we are covering both sides, and the defense, I'm very interested to see how they come back. The government was like, hey, you've misstated what needs to be proven to the jury. You weren't precluded from calling a witness. That was your strategic choice. The law is not on your side here, bruh. Like, shh, That said, no shade to Josh Duggar's attorneys. They are doing their job. It is sometimes hard to wrap our heads around when we don't like a particular defendant that they are entitled to a vigorous defense. They are entitled to have all of their constitutional rights upheld, and they are entitled, if they are convicted, to be convicted lawfully. It is hard when the defendant is awful and your gut response is do not pass go, do not collect $200, go to prison forever and stay there. We hate you. But that's not how our system works, which is a good thing because there's defendants you look at and you're like, either A, you didn't do that, or B, you did do that, but there's a really, really good reason why you did that, and we don't think you should be convicted. Cases of self-defense, cases where people harm people who abuse them, things like this. There are cases where things happen that are lawfully excused. So we want the constitutional protections to be there, even when it's hard, because we are law nerds and we can do hard things. Because what we don't want is a conviction overturned on appeal because the prosecution pulled some fuckery. That is not what anybody wants. I think personally, oh, Emily, there was a soapbox that you didn't even see coming. No, I didn't, but here we are. When prosecutors do things they shouldn't, it not only degrades confidence in our judicial system, but it also runs the risk of letting people who should have properly been convicted go free, but it also runs the risk of people who shouldn't have been convicted being convicted and sitting in jail when they shouldn't. And we need to do better. So with that, we are going to look at what Duggar's response to the government is, keeping in mind that we are not going to spew all of our feelings about Duggar. We're all allowed to have them. We're just going to see what the this is not the response, what the reply is from his attorneys who are doing their jobs. We need to have another video with Natalie Lawyer Check and talk about like the hard side of being a defense attorney, because it's not something I dealt with. There were definitely hard sides of being a prosecutor, but they're different hard sides than being a defense attorney. But it's a job. Like, my job is to protect your rights and make sure the government's not up to fuckery. And don't we all want the government not to be up to fuckery? Like, can we all agree that that's a basic thing that we stand for? Like, the government shouldn't be pulling fuckery, like, on all levels. I feel like we can agree on this simple principle. Let us go. Let us go to the Duggar. Oh, coffee. I'm going to just give a warning. Y'all know what this case is about. I don't know how much detail will be in this motion. I have not previewed it. It will be up on the screen. I will absolutely be minding the way I say things, but if this topic is triggering to you, knowing what Duggar's been convicted of, possession of illicit images of children, and the fact that the titles of some of those files have come up in previous motions, there will be a timestamp when I get to the next topic. If you want to whoop over to talking about Kristin Cavallari, it is totally fine. Protect you. If this is triggering, it is okay to opt out. You don't have to know everything. It's totally fine. But let us get into it. And if I see anything, I'll give another warning if I see something coming up. Defendant's reply in support of motion for judgment of acquittal, or in the alternative, motion for new trial. Duggar asks for these things. This is the rare case where a criminal defendant was deprived. No. I got totally distracted by the chat. I'm sorry. I love you. I got distracted. The Pawnards are relegated to the other side of the house because we have some work being done up in our attic today, and we don't want them running out the doors or into the attic as that is being done. So the Pawnards are relegated to a different side of the house because they know how to open the doors from my office so they can get in and out. Okay. I'm sorry. I had to just not choke on my words. This is the rare case where a criminal defendant was deprived of significant constitutional rights and the law requires a new trial. I should have actually timestamped because I soliloquied before I got into this. I'll timestamp when I actually start. I'll timestamp my soapbox and then I'll timestamp when I actually start. It is easy to lose sight of that when reading the government's response. Instead of actually grappling with the core of Duggar's arguments, the government sidesteps the issues and mischaracterizes Duggar's arguments in an attempt to more readily refute them. But the government's silence on the real issue speaks volumes. Look, they are good attorneys doing their jobs. And we're just going to appreciate good lawyering for what it is. The court should enter a judgment for acquittal. In its response, the government mischaracterizes Duggar's argument. Okay, I want to see how they say this. They're saying that the government mischaracterizes Duggar's argument that to obtain a conviction on either count, the government had to introduce significant evidence demonstrating Duggar knew that the visual depictions were of a minor engaging in explicit conduct, but the government failed to do so. Thus, faced with an insufficient evidentiary record to support its convictions, the government claims that Duggar argues there was no evidence he personally viewed the CSAM, which he claims is an essential element of the offense. But that is what they argued. Like, that's what I took away from the argument too. I feel like, well, without going back through all of the arguments, I feel like that's exactly how the defense characterized it. And the defense is now rewriting history in their arguments based on my memory reading the two. But if you want to go look at those together, again, this is why I pull the documents up on screen and read them. So my interpretation is not the only interpretation. You can interpret it as well. They're saying that the government asserts that Duggar critically misstates the element in the jury. They did say that. Critically misstates the element the jury considered when determining his guilt. The government did say that. To be clear, in context of this court's Rule 29 analysis, viewing the evidence in the light most favorable to the government, evidence that Duggar actually viewed the visual depictions allegedly recovered from the desktop computer may very well be legally sufficient to indicate knowledge that the desktop computer contained visual depictions of a minor engaged in explicit conduct. However, the evidentiary record is insufficient to sustain a conviction on either count in that regard. Instead, the undisputed evidence at trial revealed that many of the files allegedly recovered were never viewed by any user of the computer, and all of the files at issue were deleted shortly after they were allegedly downloaded. I don't think it's in contention that factually the issues were downloaded, deleted, downloaded, deleted. If you want me to talk about that pattern of behavior and what I think it means, I can do that later. I've talked to a number of other prosecutors about this, just as a part of us talking about the things we do in the day. But with that, I don't think that factually mischaracterizes what both parties have said. However, the elements of this are that he received it over the computer and that he then possessed it on the computer. So you have to show that it was on the computer and he had control of the computer. And then they talk about demonstrating that he knew what the content was. And that's where the government got into the file names. And this is going to talk about this. And I'm going to try to minimize this as much as I can. Let's see. Against this backdrop, the only response the government provides to Duggar's actual argument that no evidence was introduced to demonstrate, Duggar's knowledge. And again, knowledge can be got by circumstantial evidence. So they are also sidestepping the issues. Knowledge can be proven by circumstantial evidence. Knowledge can be proven by circumstantial evidence. Circumstantial evidence means things that point to a fact, not direct knowledge of the fact. And the thing that's used in some of the model jury instructions is like, oh, you see somebody or multiple somebody's walking into a building. You're staying at the new Star Wars experience at Disney and there are no windows. The windows show space, so you can't see actual outside, but you see a number of people walking to check in for their Starship adventure, and they are shaking out umbrellas and they are dripping wet. Now, you have not seen outside. You have not seen the sky. You have not seen water falling from the sky. But when you look at those people, you're like, oh, it's probably raining, because numerous people have come in wet and shaking off wet umbrellas, even though you've not seen it. That's circumstantial evidence that it's raining outside. You can infer a thing from a thing versus stepping outside, looking up, getting wet, and being like, oh, fuck, it's raining. So, knowledge, you generally can't know what someone is thinking if they don't tell you. By the way, this goes for relationships as well. Ask people. You can't know what people are thinking unless you ask them. Ask people what they're thinking. So the jury had a lot of information. I'm not done yet. The jury had a lot of information where they can use the facts to assume knowledge. They can say when the police show up or the investigators from Homeland Security show up and say, hey, we have a search warrant. Do you know what this is about? And Duggar looks at them and go, oh, was somebody downloading child pee? He said the whole thing. The jury can assume that he knew that it was present, because why else would you say that? If I'm running a car lot, I'm worried that maybe someone has stolen from me. Maybe someone's doing something. Maybe a car I have on my lot was stolen and they need it. Like, where your brain first goes is something that a jury can infer facts from as circumstantial evidence. Additionally, when you look at the file names, the jury can be like, if you see this file name, you know what the fuck it is. The jury can also infer that from the lengths gone to partition a computer, download multiple programs, to seek out these files and then download them. The jury can say all of these things allow me to say that he knew that he possessed these things. A jury's allowed to make that factual determination. The defense is saying the jury cannot make that determination because the record is insufficient for them to make that circumstantial decision or to find the circumstantial evidence of knowledge. And the government is saying, literally, the government is saying, bitch, please, there's plenty of evidence here. So, and they're doing their job. They're doing their job. They're saying that no evidence was introduced to demonstrate Duggar's knowledge that the visual depictions were allegedly on the desktop at any given time. And is that a user of the computer? What? I've got to back up to the beginning because I chopped this sentence up and now it's difficult. Against this backdrop, the only response the government provides to Duggar's actual argument that there was no evidence that no evidence was introduced to demonstrate Duggar's knowledge of the visual depictions were allegedly on the desktop at any given time is that the user of the computer played certain videos with titles that would be evident to the person downloading them, that a user of the partition navigated to folders and viewed CSAM or images of illicit images of kids in a thumbnail format. To be clear, Duggar is not arguing that certain images introduced by the government at trial do not meet the legal definition of CP. Oh, good. The threshold question raised in this post-trial motion is whether, even in the light most favorable to the government, the evidence was sufficient to establish Duggar's knowledge that the visual depictions were on the computer during the 3 days alleged in the incident. And again, this is where circumstantial evidence comes into play. At the end, the government's argument boils down to the theory that the partition was accessible only through a password that had been associated with Duggar in the past for other purposes, and that therefore he must have been the user who accessed the material, notwithstanding. Well, that wasn't the only thing they showed. And here's the thing. In the defense motion, they said the government relied on the password. And in the government's motion, they said, no, We relied on the password and the photos that were GPS stamped showing he was at the car lot at the same time, and the fact that the employment records show no one else was working at the car lot during that time, and the fact that when we showed up, he said the words, and the fact that he was texting his wife, I'm at work going to be late. Like, they relied on a lot of evidence to build that circumstance, which is what we've talked about since the beginning of this case, because proving someone's at a keyboard is hard if you don't have visual depiction of them. So you have to use all of the circumstantial evidence to prove the person was at the place doing the thing, and the jury agreed. So I think that the defense is picky choosing the facts here, but that is their job. They say the government then identifies 2 file names, arguing that these videos were allegedly viewed by the user of the computer as opposed to being deleted before being opened, like many of the other files allegedly recovered from the computer. Specifically, the government identifies a video titled P-word Mom, which was allegedly recovered from the desktop computer. We don't need to keep saying allegedly. He was convicted. However, at trial, the government went out of its way to emphasize that only the first 29 seconds of this video was ever played by a user of the computer before it was deleted. And critically, the first 29 seconds of the video contained no visual depictions of minors engaging in explicit conduct. As such, even if this court were to conclude for purposes of this post-trial motion that for judgment of acquittal, that in the light most favorable to the government, Duggar played the first 29 seconds of this video, that does nothing to establish the mens rea element to either count. And with respect to the other video identified by name in the government's response, that's one video. There were multiple. And with respect to the other video identified by name in the government's response, the government introduced no evidence whatsoever concerning how long that video was played. It doesn't have to be played. You're missing the fucking point. It doesn't have to be played. It doesn't have to be played. It has to be possessed. It just has to be possessed. It does not have to be played. They don't have to prove that he watched it. They have to prove that it was on the computer and that he knew that it was these types of images. Ultimately, Duggar maintains his innocence and does not seek to relitigate this entire case in the context of a Rule 29 motion. But that does not change the bottom line. The government failed to introduce any evidence that would allow a reasonable jury to conclude that Duggar knew the visual depictions allegedly recovered from Wholesale Motor Cars computer were of minors engaging in explicit conduct. Look, here's the thing. We've seen the titles. We know what some of these video files were. A jury gets to make that factual determination. And again, the defense is arguing that there's not enough that the jury can make that factual determination. I disagree. I think the court is going to disagree. They're saying that the government's mischaracterizing the argument. I think the defense is also cherry picking the argument. But again, if you want to look at the hair splitting of what it is to actually be a lawyer, if you're like, oh, I think being a lawyer would be fun, look at these 2 motions and see how these 2 different sides are having to parse an argument. This is part of it. Parsing an argument and saying, I am parsing an argument because this is my job. They're saying in the alternative, the court should grant Duggar a new trial based on what I perceive as their strategic decision to not call the witness Caleb Williams. If you want a full discussion of Caleb Williams, that will be in the other video. They're saying that the government fails to meaningfully address evidence that it deliberately played games with its obligation to disclose Brady and Giglio material. The Brady or Giglio, I always say Giglio because it's funny to me and I'm 13 in my brain, but Giglio, whatever. Brady is an obligation that the prosecution has to turn over material exculpatory evidence. The prosecution argued that they turned over the evidence, and even if they hadn't turned over the evidence, kind of arguendo, that this evidence is not Brady material because it's not material nor exculpatory. The defense is arguing that this is material and exculpatory. Here's the thing the defense keeps leaving out of their motions. There were text messages between Williams and Duggar. Duggar knows Williams. The defense attorneys have access to Duggar. So Duggar could have told them, like, this information was in the possession of the defense too. The defense is arguing they tried to interview Williams and he didn't want to talk to them. So they subpoenaed him for trial. They could have called him. I think the court properly limited the inquiry to establishing foundation. There are documentary items of evidence indicating that Williams was not within the state of Arkansas on the days these things happened. They say that the chronology paints an important picture. Williams called and emailed government counsel on November 24th, 2021, making numerous statements relevant and material to the case, which were potentially exculpatory. That is at issue. The government disagrees with that assertion. And the government kept this information to itself for the next 3 days. I believe that's over Thanksgiving. Let me tell you the amount of times I checked my email over Thanksgiving. None. Turning it over the Saturday before trial. In that email, Williams wrote, "I was completely mistaken about not being at the Wholesale Motors lot during the time I was in Arkansas between May 8th and May 11th. He added, "I apologize for the mistake. I had no intention to mislead you all." But when we read the entire email in the last video, it also said, "I may have been there, but the relevant time period for this case is the 13th to the 16th. On May 11th, the computer at Wholesale Motor Cars didn't have a partition on it based on the forensic evidence. Trial began on November 30th, 2021, and the government presented evidence over the next 7 days. During almost its entire case in chief, the government failed to disclose to the defense that it received another email from Williams on the first day of trial. In fact, it was not until Sunday, December 5th. This is, again, restating the motion we've already gone through. They say that tellingly, the government doesn't even attempt to justify this pattern of deliberately delaying disclosure of material exculpatory evidence. Again, a witness not being there at the time in question, I don't think is material or exculpatory. And I don't think the court will find it to be such. If I thought it was material and exculpatory, I would be yelling, "Fuckery, where is the fuckery?" Don't do that. Kind of the way I was yelling during the Rittenhouse trial. But I'm not. And you know why I'm not? Because it's not. Tellingly, the government does not even attempt to justify this pattern of deliberately delaying disclosure material exculpatory evidence related to Williams in its response. And am I wearing the wrong glasses? No, these are the reading glasses. Why can't I see? Today is hard. We're wearing the right reading glasses and we're still struggling. All right, it's just going to be that way today. It's just going to be that way. This matters because Duggar, they say, was unfairly prejudiced by these 11th hour disclosures. Specifically at trial, 2 issues of paramount import included: 1, whether any person other than Duggar was present at the car lot on certain days in May 2019. Notice that they don't say the days. Certain days, May 13th, 14th, 15th, and 16th, not May 11th. The chronology does in fact matter here, defense. And 2, whether any person other than Duggar who had physical or remote access to the desktop was familiar with the password Intel 1988. The 2 Williams email which place him on the lot, no, it doesn't. The emails say he may have been. It does not. Look, Gumby. There's only so far you can stretch these facts, but you attach the email. We read the email in the last video. The email says may have been. The email does not say was in fact. The email says may have been because was at the brothers' car lot. Oh my God. That mischaracterizes the facts to the court. The 2 Williams emails which place him on the car lot disagree, which unambiguously indicate his familiarity with Duggar family passwords, but not Josh's, drew him further into the crosshairs as someone who should have been meaningfully investigated. They interviewed him and he said, "I don't know Josh that well and I wasn't there." So, okay. But instead of disclosing these emails upon receipt, as the Constitution requires, if they're material and exculpatory, The government hid this information from the defense until it was too late for Duggar to effectually utilize it at trial. I disagree because the defense still had time to call him. And the court said, you've got to establish relevance. And they said, negative, ghostwriter. We're not going to call that witness. This argument's just making me mad all over again. It's just rehashing what was in the first motion. A reply is supposed to address the reply. They're just rehashing the other motion, which, I mean, what else are you going to do? When you can't argue the facts, just argue the Constitution. Rather than addressing the clear-cut discovery violations, the government attempts to downplay the significance of the emails by offering several conclusions it claims to have unilaterally reached after reviewing them. Williams never claimed to know the defendant's password. True. Williams' email provided no reason to conclude he had access to the defendant's computer between May 13th and 16th. I agree with that reading of the email. Let me know if you agree. You've watched the other video. Or could have committed the offenses. Williams sent the email on the first day of trial because he was likely alarmed by the defendant's continued attempts to publicly blame him, maybe, for crimes he did not commit. And Williams' email confirms Williams did not have access to the defendant's computer between May 13th and 16th and did not claim to know the defendant's password. The elephant in the room is that these possible conclusions are not the prosecution's to make in a federal criminal trial. They are the jury's. Then call the witness. They say, contrary to the government's self-serving conclusions, William expressly acknowledges in the 2 emails he sent to the government that he had misled law enforcement when he was on Duggar's car lot, about when he was on Duggar's car lot, and that he had more passwords he was willing to provide. But he said those passwords were of Duggar's brother, and he said he may have been on the car lot. He did not say that he was, but okay. They say the entire prosecution team buried their heads in the sand. Okay. Under Brady and its progeny, prosecutors have a duty to disclose to the defense all material evidence favorable to the accused, including impeachment and exculpatory evidence. The government argues that it's not material nor exculpatory. I think the court will agree. The defense goes on to say, had this evidence been timely disclosed, Duggar would have had the ability to cross-examine law enforcement witnesses concerning their failure to, among other things, follow up with Williams about more passwords. Here's the question that is screaming in my brain. If Duggar gave Williams his password, wouldn't Duggar have just fucking told his lawyers that? Because wouldn't he know? Wouldn't you know who you gave your password to? Wouldn't Duggar just tell Williams that? And then wouldn't Duggar's investigators have to go find Williams and interview him? He has equal access to this witness because it's about whether he gave this witness his password or not. And if he did, tell your lawyers so they can investigate. You're the defendant. You aren't saying you weren't at the car lot. You aren't saying you didn't work at the car lot. You aren't saying you didn't know this individual. You, Duggar, have the ability to also lead an investigation because you have access to your phone, to emails sent, to text messages sent. You have equal access to this. The government is playing investigation. Well, no, they're not playing. They're actually investigating. They have to follow the information that they have. If the information doesn't lead them to this person, it doesn't lead them to this person. They don't know other than what they've downloaded and what they've looked at. Duggar knows. So Duggar, if you gave them your passwords, your defense investigators should have gone out and interviewed this person when you were arrested. You had almost an entire year to do that. So I'm just saying. I'm just saying. But okay, blame the prosecution. I mean, that's what you got to do anyway. Just blame the prosecution because that's what you need to do. The government claims to not have even reviewed Williams' email concerning more passwords until the evening before it rested its case, making it clear that rather than investigating what Williams knew and did not know, the government buried its head in the sand and withheld the information to ensure Duggar's trial firepower would be irreparably impaired. You had equal access to this witness. Indeed, as the government counsel acknowledged the morning after Williams' email was disclosed, we have not spoken to Williams since he sent the email. Right, because they didn't care. You know why they didn't care? Because it wasn't relevant. You know why it wasn't relevant? Because he wasn't on the car lot those days, but okay. They're doing their job. 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 Instead, they say the government simply claims that at some point before Williams' email to say he had found a few more passwords if y'all want them. Again, he said they are passwords of Duggar's brothers, not Josh. Agent Faulkner purportedly asked whether he knew the defendant's banking password, and he said no. You know why he asked that question? You know why? You want to know why? You want to know why? You know why he asked that question? Because the partition password for the partition where the images were was the same as Duggar's banking and social media passwords. How many people do you give your bank password to? Just ask yourself that question. I'm sure the jury did. How many people have the password to my fucking bank? So, with that, that's why he asked. They didn't ask, do you know the partition password? They asked, do you know the banking password? Because the government knows it's the same. And once if I'm on a jury and I'm like, oh, he used the same password for his bank and social media accounts as he used for this partition. As a juror, for me, I'm like, well, let's start hammering the nails in the coffin now because that's pretty strong evidence. Then you add the fact that he said, what, was somebody downloading CP on my computer? Weird. Is that why the police are here? Strange. You add that all together and there's a pretty solid record. These are all things the jury can consider as to whether Duggar created the partition and whether Duggar was the only one that had access to the partition that kept him sneakily away from the covenant eyes that would tell his wife if he was like peeping at whatever on the internet. Also, if your banking password is the same as other passwords, I've said it here before, and you know that Nord has worked with me for over a year now. Today's video is not sponsored, but others are. Nord has a Nord Pass. And NordPass keeps all your password and helps you generate secure passwords. Don't use the banking password for fucking anything else. It can be hacked. Don't do that. Just saying. As someone who recently had to yell at their father about this. All right. I've ranted enough. I'm sorry. First, asking Williams whether he knew Duggar's password is actually not the same as investigating. I kind of love this sentence though. Asking Williams whether he knew Duggar's banking password is actually not the same as investigating whether he was familiar with the password Intel 1988. I mean, but it kind of is if it's the same password. Investigators aren't going to give you the information. Investigators aren't going to say, hey, do you know Intel 1988? Do you know that's Josh Duggar's password? Because they taint the investigation because they've given you the information. And if the investigators said that and it was something the defense didn't want out, the defense would be like, you told them the answer. That's not how you ask investigative questions, but all right. I realize they're doing their job. And perhaps more importantly, completely ignoring Williams' offer to provide more passwords, not of Josh Duggar. More passwords, not of Josh Duggar. I'm going to stop ranting because I'm just saying the same thing over and over. I apologize. This is just... They say again that the government purposely... See, they're repeating their arguments again and again, so my rants keep repeating. I keep getting re-triggered to rant about the same thing. We're going to cruise on by. We're going to fly by these things. They say that the government purposely turned a blind eye. At least they didn't stick their head in the sand this time. To the possibility that Williams may have known the password to the partition. If Duggar gave him the password, y'all could have. In this day and age, it strains credulity to believe that the prosecution team of 3 federal prosecutors waited days to read unsolicited emails from a witness they anticipated the defense would call each time they received them. And even the prosecution team clings to the verb reviewed I've got to read that sentence again because it's awkward in my brain and it's not making sense. In this day and age, it strains credulity to believe that a prosecution team of 3 federal prosecutors waited days to read unsolicited emails from a witness they anticipated the defense would call each time they received them. And even the prosecution team clings to the verb reviewed every time this issue has been raised. Instead, the question before this court should be why they waited so long to disclose these emails to the defense, and the chronology paints a clear picture. The government withheld the 2 Williams emails because they didn't think that they were material and exculpatory. I'm sorry. The government withheld the 2 Williams emails from the defense long enough to ensure that Duggar was unable to make effective use of the information at trial, including when cross-examining the government's lead agent on topics that included law enforcement's insufficient investigation and singular focus on Duggar instead of other possible suspects, which was ruled on in the motions in limine. There was a motion in there. My memory is not ideal, but there was a motion in limine about alternative perpetrator evidence that was ruled on. So they couldn't have gotten into that without calling this witness. And then they could have called the government witness themselves if they had them under subpoena. The central theme of Duggar's defense was the inadequate investigation performed by law enforcement and the government's unwillingness to consider any possibility that anyone other than Duggar could have committed the offenses charged. Had the defense team been aware that Williams had offered to provide, quote, more passwords, not of Duggar, to the prosecution team, that the prosecutors and law enforcement agents had refused to take them up on the offer, Duggar could have meaningfully impeached Special Agent Faulkner. I think that's a reach on this topic, because the jury would have been like, oh, more passwords of Jed Duggar? It's fucking irrelevant. Okay, they're saying it's a clear-cut constitutional violation. I can't stretch far enough to see that being clear or otherwise. They're continuing to talk about this being exculpatory. They are rehashing the entire motion, and we're not here for it. Duggar was prevented from calling a necessary witness again. Let's just get into what they're arguing. The government argues that the notion that Caleb William committed these offenses is pure fiction, but setting aside the fact that whether evidence involving Williams would have injected reasonable doubt is a question for the jury, not the prosecution. That is not the issue before this court. Whether inadvertently or strategically, the government misstates Duggar's actual argument. Okay. Specifically, the government incorrectly argues that Duggar's theory is that Williams remotely accessed Duggar's computer to set up the partition, and this was disproven by his own expert. But this is a straw man. Again, they're setting up a fake argument. They say the government is, oh, I sorry. I didn't pull it back up. I was just reading to myself. There is absolutely nothing in the record that would support the government's assertion that Duggar ever advanced a theory that whoever allegedly set up the partition on the work computer did so remotely. That's not what they said, though. They didn't say set it up remotely. They said accessed it remotely. Set up and access are 2 different things. They're doing exactly what they're accusing the government of doing, but this is lawyering. This is why lawyering sometimes makes you want to scream at people all the time. They're saying that Duggar was not the only person that had the opportunity to create the partition allegedly found on the computer. It doesn't matter who created it. It's who accessed it when the shit was downloaded. They say, premised on the fiction that Duggar's theory was that Williams could have remotely set up the partition, the government repeatedly argues throughout its response that Duggar's only purpose for calling Williams to testify was to introduce evidence that Williams was a convicted sex offender. To the contrary, Duggar sought to call Williams as a witness because he had the opportunity, the know-how, and the motive to commit the charged offense. But you have to lay a foundation before you can ask those questions. Depending on his responses to the questions posed at trial, Williams' credibility was readily impeachable. In short, Duggar sought to introduce evidence that Williams may have lied or been mistaken about his whereabouts at certain times. Indeed, Williams made clear to the government in one of the 2 belatedly disclosed emails that he had misled law enforcement concerning his whereabouts, even if inadvertently. Thus, while the government claims to have concluded that Williams was not in Arkansas on May 13th through the 16th, This should not have precluded Duggar from adducing the evidence that Williams may have been mistaken or lying about his location on certain dates. Then call him as a witness. The court never said you can't call. I'm done. The court never said you can't call him as a witness. The court said you have to lay a foundation to call him as a witness. You have to establish relevance, and then you can impeach him. And they chose not to call him. You don't get to undo that decision. Sorry, defense. You don't. That's not how that works. That was a strategic call. They say, the defense proffered even if Williams denied being on the car lot on May 13th. This was an assertion which should be subject to impeachment, but impeachment by evidence, not impeachment by prior convictions. That's not how the rules of evidence work. Subject to impeachment because the only evidence to the contrary where Williams had provided to the government was concealed all metadata. Oh, so they're saying that the documents concealed all metadata. I'm interested how they're saying they did that. And apparently his mother's willingness to say he was not there because it was Mother's Day. They say in the government's view, this was all a fiction because Williams denied to investigators that he was in Arkansas during that time frame because he had had a receipt from an Apple store in St. Louis, Missouri, dated May 11th, which could be verified by an Apple representative because Williams' mother was willing to testify he was in Illinois starting on May 12th. And provided photos that he was at his family home dated those days. Again, cell phone evidence works two ways. You know. Did I say that the Kristin Cavallari lawsuit has pictures? It has pictures of celebrities wearing jewelry. We're going to get there. They say, to be clear, Duggar had a constitutional right to call Williams at trial, and you were not precluded from doing so, and I am done with this argument. The court said you could call him and lay a foundation. This argument is not going anywhere. It can go on for another 3 pages, but it's not going anywhere, and the court is not going to agree with you. Jenks Act and Rule 16 violations by the government. Again, they're saying that there was improper expert testimony. They are not even rebutting really the government. They are just restating the argument from their initial motion. They're saying at trial, a critical dispute arose. Whether the username Dell_1 could be manually input as the username on a Linux partition of the work computer. I can imagine a jury sitting there rolling their eyes over this. This is the stuff that is so important to lawyers. It's like, no, you can't even create that username. And a jury's like, oh my God. But he said, was somebody downloading CP? Was somebody downloading this? But he used the same account password for this other stuff. A jury might not have found this super relevant. The attorneys found this super relevant. And that happens so often in trials that are deeply specific with expert witnesses, where the jury is just like, I'm done. I'm done. And that's just supposition. We don't know what the jury found most important. That's just looking at a lot of juries in the face. A critical dispute over whether Dell_1 could be manually input as a username for a Linux partition, and whether the software uTorrent could be downloaded from the Linux Snap Store. When he testified during the government's case in chief, that's the first part, the investigator concluded that the username could be manually created and that uTorrent could be downloaded from the Snap Store. During the defense case, their expert disagreed with the conclusions on these points. The jury's allowed to find one expert more credible than the other and take the opinion of one, not the other. Thus, when the defense rested its case, the jury was left with the opinion of determining which expert's testimony was more credible, but the story did not end there. Look, defense. You know that the government gets a rebuttal. You know that this happens. You know that this is true, man. The government gets to call more witnesses. Their burden is higher. Their burden's beyond a reasonable doubt. So the defense gets their case in chief and they get to try to poke holes, and then the defense gets a rebuttal. We're calling that now. The defense gets a rebuttal to try to plug those holes up of reasonable doubt. Breathe, Emily, breathe. All right, I've now got my emotional support facial roller. I didn't know this was a thing until I watched this season of Real Housewives of Beverly Hills, but it works surprisingly well. Thank you, Sutton. We're gonna emotional support roller. Ooh, that actually feels really good on the neck. Okay, let's keep going. They say the government opted to put on a rebuttal case. And call their expert again to the stand. During his direct examination, the government sought to introduce screenshots that the expert had created when he claimed which he claimed showed that he was able to manually input the username and download the uTorrent program from the Snap Store. When the defense objected to the use of these screenshots on the basis that they had not been disclosed, the prosecution expressly represented to the court outside the presence of the jury that they had created after the testimony. But the testimony came up during the case in chief. So they say, however, on cross-examination, Fortall testified that he had created these screenshots before trial. Okay. The defense then formally moved to strike the exhibits and to strike the testimony. He already made that testimony on direct, though, so it's not going to get stricken. The court denied the motion and said that the screenshots were demonstrative and that they were not, in fact, evidence. Look, when you summarize documents and when you summarize things, you can give demonstrative evidence, charts and shit to show the jury, like, this is how it works. The jury doesn't get those back in the jury room. It's to help them understand the bulkier underlying evidence. You're allowed to use demonstratives. They don't go back to the jury room. The jury's told that this demonstration is not evidence. The words, the testimony is evidence, and that testimony was already elicited at direct. Bleh. Allie said, Tati has been using that same roller for years. I probably bought it off of a link after watching one of her videos. I love this roller. I've had it for years. That's probably where that came from. So they go on to say that the defense expert would have been able to further test the theory and could have provided more pointed testimony about why his conclusions were incorrect, or alternatively formed a different opinion. But he testified about it indirect. And he testified about it indirect so the defense expert knew. So, no. Furthermore, the government argues that the screenshots prepared by Fortall in advance of trial were somehow inculpatory, and argues that in the Eighth Circuit, prosecutors need not turn over inculpatory information. We'll see what the court says about that. I don't think it's going to matter because the court determined that they were demonstratives. A new trial is the appropriate remedy for the Rule 16 violation. I don't think that's going to happen. Impermissible expert testimony about geolocation. Let's see if they restate anything new. In response to Duggar's argument that testimony concerning geolocation is expert testimony that the government did not provide notice that Fortall would opine on the subject, the government argues that this is not expert testimony, and that even if it was, Fortall was qualified to provide it, and appropriate notice was given. The government argues that the Crawford case cited by Duggar's motion is inapposite. Therefore, the district court concluded the government will need to provide an expert witness to explain and support the methods used by Google to obtain the geolocation data. If it intends to use it as evidence at trial, it will be sufficient to call a Google representative to authenticate the records based only on accuracy under FRE 901. In its response, the government notes that Fortell testified that he reviewed the EXIF data captured from the iPhone and the input the coordinates on Google Maps. The government does not claim that the expert understands how Apple creates their data or how Google interprets it. Nonetheless, attempting to distinguish this case from Crawford, the government simply argues that Fortall had utilized this technique for years. They did do that. But this does nothing to alter the fact that the Crawford court wisely concluded that even producing a representative from Google, and also Apple in this case, to authenticate the records spit out by the technologies would be insufficient. The government must do more to explain how these technologies function, which I want to see how the court handles this part. Because there is an argument that, like, well, is Google Maps infallible? How is Google Maps representing that data? How do we know how EXIF is captured and exactly when? Is it captured at exactly the moment? Who gets to know? And do you need an Apple representative to come in and say, this is how it's done, or to get a Google representative to come in and say, this is how it's done? It is a good argument. And as technology moves forward, foundation for technology is something that is very, very necessary. So I will be interested to see how the court does this. So Additionally, the government accuses Duggar of cherry picking a quote from United States versus Boyajan, I think, concerning the reliability of EXIF data. While the government points out that that court drew a distinction between standalone cameras and camera phones, it did so for a different reason, namely the standalone camera EXIF data must be manually entered, whereas camera phones automatically create EXIF data, but that does not mean EXIF data cannot be manipulated by a user when it's automatically created by a camera phone. A simple internet search reveals exactly how this can be done by the most novice user. Thus, Duggar's point that the EXIF data is inherently unreliable is in no way weakened by the government's own cherry picking quote. This is the argument I want to see. That's it. I want to see that argument. I want to see the court address this. The rest of it, not so much, but the law in the realms of technology and foundation for technology is needed, and it's an area that is going to be growing. Look, if you are in college, if you have kids in college, if you're interested in law, if you're interested in doing expert testimony, understanding the back end of how all of this technology works and being able to explain that is going to be hugely needed in the area of law. So if you want to be an in-demand lawyer, a computer science degree is going to be tremendously helpful. Just how I'm seeing trends in law going. We are almost done with this, and then we are moving on. Finally, the government notices that the subject of this testimony was noticed. I agree with the notice. I'm very interested to talk about and to see what the court rules on the EXIF data. It's something I definitely want to do a deep dive into. So I think, though, if EXIF data was manipulated, it would probably show, and this is speculation on my part. I am not an expert. I want to bring an expert on to talk about this. But I think if EXIF data was changed, you might be able to see that when you have an entire download from the device. By the way, I don't know how many likes we're at, but don't forget to like and subscribe. Do the things. And if you're watching and you're subscribed, you can come and join the chat, please. Thank you. We're trying. Let's see how close we are. We are close to 199, and then we're going to be there. We're close to 199. So let's see if we can make it bing, because we're close. At the defendant's request, the government must give the defendant a written summary of any testimony the government intends to use under 702, 703, 705. They notice the expert. I don't know if the defense is arguing that they didn't say he would be testifying about the EXIF, et cetera, et cetera. Let's go to their summary. The court should dismiss count 2. That's going to happen. Conclusion, based on the foregoing, I think that count 2 is going to get dismissed. I want to see the court address the EXIF data. I think that that's all we're going to get. I think that he is going to get sentenced on April 5th. The court should rule on this soon. If I am not in New York for the Jen Shah trial, which I suspect is getting postponed, I will take a poll. Should I just go to Arkansas for this sentencing? I feel like that should probably just happen, and I will. So if I'm not in New York for Jen Shah's trial, I think we might have to take a trip to Arkansas. I can get to Arkansas from Tennessee. This is the great thing about being in Tennessee. Like from California, it was like, ugh, I have to go somewhere not in California. Like I would go to San Diego, but from Tennessee, it's like, oh, I can get to places. We're just here in the middle. All right, let us swoop. Let us talk about this new Kristin Cavallari lawsuit. Y'all are going to love this. I'm excited. All right. And for everybody who sat through all of that to get to the Kristin Cavallari lawsuit, thank you. I appreciate you. Don't forget to like and subscribe. Follow me on the socials. Do the things. I'm here for you. Let me make sure I've got the right lawsuit pulled up. You guys are like, yes, go to the sentencing. All right. I'm telling you, if the Shah trial gets delayed, I'm doing it. Let's pull this up. So let me swoop. Do y'all remember Kristin Cavallari? She's had a lot of reality TV shows. I have not followed the crew from Laguna Beach and The Hills since The Hills days. The Hills was kind of iconic in reality TV shows. So was Laguna Beach. Like, I love reality TV. I have loved reality TV in my soul for a very long time. I have not followed up with the crew from then. I think that LC is married to an attorney. I think Kristin Cavallari got a divorce. I think she lives locally here in somewhere in the Nashville area. but she is getting sued. This lawsuit is brought to us by the law firm of People, Salts, People. So, yes, it is a new Saltsy lawsuit. Yay! Saltsy suing Kristin Cavallari. No, that's not true. Saltsy's client, jewelry designer Rachel Beth Katz, suing Kristin Cavallari and her business Uncommon James. I will do a deeper dive into other things that have gone on with Uncommon James if it's necessary. But for today, we are just going to go over this new lawsuit filed in U.S. District Court, Central District of California, for federal trademark infringement, federal copyright infringement, trademark dilution, violation of business and professions codes, unjust enrichment, and constructive trust. Constructive trust is something we just recently saw in the Brad Pitt Angelina Jolie lawsuit. If you haven't watched that, go ahead. It's on the channel now. We talk about constructive trust there. Violations of BMP come up in a lot of our California cases, but the trademark dilution and the trademark infringement we talked about with Satan shoes and other things. So let us talk about this lawsuit because, we love a salty suit. Plaintiffs Rachel Beth Katz and Rachel Katz LLC, collectively known as plaintiffs through their counsel, complain against defendants Cavallari and Uncommon James, as stated below. Nature of the action. Plaintiffs create and design unique jewelry for sale to consumers throughout the United States. Plaintiffs own these designs in exclusivity. They use them for profit by selling individual pieces of each jewelry design. Defendants have knowingly and intentionally used at least 2 of such designs in the production of unauthorized knockoff or imitation goods, which infringe on plaintiffs' intellectual property rights. Jurisdiction and venue. The court has original subject matter jurisdiction over plaintiffs. Uncommon James has stores in LA, so it's going to be really hard to argue with this because Uncommon James has stores in LA. The parties, we're almost done with the coffee. We're going to switch to water. Rachel Katz is an individual residing in the county of Los Angeles. Rachel Katz LLC is an LLC registered in California. Cavallari is a resident of the city of Nashville in Tennessee. Uncommon James is a LLC registered in Delaware doing business within the jurisdiction of this court because they have a retail location at the Grove. Yep. So again, they've availed themselves of the form of California because they do business in California. And what's interesting is they say that defendant, to be certain, according to defendant Uncommon James's website, it was and is founded and creatively directed by Kristin Cavallari. Defendant Cavallari designed the jewelry being sold on defendant Uncommon James, and defendant Cavallari has a hand in every facet of defendant Uncommon James LLC, which is funny. They created a link. I'll probably screenshotted it too, because this is their our story page. And it says founded and creatively directed by television personality and fashion entrepreneur Kristin Cavallari. Uncommon James is a collection of timeless, effortless, and sophisticated jewelry for women on the go, inspired by her wide array of life experiences, travel, and exposure to fashion from around the world. Kristin saw the need to create a jewelry brand that is both versatile and affordable for women of all ages and backgrounds. Embodying her own sense of style, Kristin designs pieces that are feminine with edge, classic yet trendy, and simple with a pop of personality. Made of delicate metals and gemstones, Uncommon James is crafted to seamlessly transition from day to night, worn alone or layered. But again, it says that she designs it, which is part of why she is also being sued. Again, you know how much I love using someone's words against them. Quote, I've poured my heart and soul into Uncommon James, having a hand in every facet of the company. This brand is a true reflection of my personal style. Well, when your words and your websites come back to bite. Let's continue on. Defendants does 1 through 50 are individuals or entities whose true names are not yet known. Plaintiffs are informed and believed and at all times mentioned herein. I'm not going to read the header to every single sentence, but know that allegations and shade are what lawsuits are made of. These are allegations. They are not statements of fact. These are allegations in a lawsuit. But some of the things might be factually based. Well, of course they are. They have to have a factual basis to be filed in a lawsuit. But lawsuits, allegations, and shade. Though I will say someone having a copyright registration is, probably less of an allegation, more of a fact. Plaintiffs are informed and believe that Kristin Cavallari and Uncommon James were the agents, servants, and employees of each other. These, again, are the legal foundational bits of the lawsuit before we get to what they are saying happened. Plaintiffs are informed and believe that defendant Uncommon James is defendant Kristin Cavallari's alter ego, which we saw in the Triller lawsuits, alleging that Teddy Fresh, the clothing company of Ela Klein, was the alter ego of the H3 podcast. I feel like that's a stretch, but we know that Kristin Cavallari designs under Uncommon James, so depending on how it's organized, the alter ego saying, look, Kristin Cavallari and the business are interchangeable, like in the Cardi B defamation suit with Tasha K. Tasha K and her LLC, KB Studios, are basically one and the same. It's her business wing of what she does. Way less of a stretch here than it is in those Triller suits. Accordingly, defendant Kristin Cavallari is using the corporate form unjustly and in derogation of the plaintiff's interest. If the acts of any particular defendant are treated as those of a business entity alone, then the other defendant's infringing conduct would be permitted to continue, which is an inequitable result. So they are both responsible for this. Plaintiff's intellectual property. We need more water. Plaintiff Katz, we're not going to do full names, no disrespect, just shortening the amount of words. Plaintiff Katz owns and has owned prior to the infringing acts complained upon copyright registration number that, which included two-dimensional graphics depicting jewelry styles designed by plaintiffs. Plaintiff Katz owns and has owned prior to the infringing acts U.S. copyright additional one. Plaintiff Katz also owns a trademark from the PTO, number this one, which describes the registered design mark for jewelry styles designed by plaintiffs. The trademark registration describes the mark as follows. The trademark consists of three-dimensional configuration of a ring featuring two parallel bands that are connected by arrows pointing towards each other forming the band. We will see pictures of the jewelry, don't you worry. Katz's trademark registration also includes two-dimensional graphic depiction of the protected jewelry design. Plaintiffs' trademarks, copyrights, and associated intellectual property are hereby collectively referred to as designs. Defendant's infringing conduct. Plaintiff Katz is a renowned jewelry designer who regularly sells, licenses, or otherwise exploits her fine jewelry design to consumers via retail sales. Plaintiff's products are marketed and sold to affluent clients. We'll go to her website in a little bit and take a look. Including but not limited to a devoted fan base of celebrities and people of notable influence. Well-known entertainers and notable people of influence routinely wear and feature plaintiffs' jewelry on red carpets, press and award events. Such celebrities and people of notable influence that have been photographed wearing plaintiffs' jewelry include but are not limited to photos: Michelle Obama, Angelina Jolie, Cindy Crawford, Sandra Bullock. Plaintiff Katz is a manager and controlling member of Rachel Katz LLC. Collectively, plaintiffs do business as Rachel Katz Jewelry. Plaintiffs designed and offered for sale two distinctive jewelry pieces, which are her diamond dagger ring and her diamond dagger cuff. Those pieces use her dagger style of jewelry design, which constitute the designs protected by plaintiffs' registered trademarks and copyrights. The dagger style jewelry of Rachel Katz Jewelry design of Rachel Katz Jewelry consists of two gold-colored parallel bands that come together at the ends to form a V formation and curve around the wearer's wrist or finger. The V formation is lined with 7 diamond studs. A single diamond marks the closing of the V formation, and a row of 3 diamonds extends down each side of the V. Well-known entertainers and notable people of influence routinely have been photographed wearing the diamond dagger ring to red carpet press and award events. Some celebrities and other people include Taylor Swift, local Tennessean, Charlize Theron, Kate Hudson, Heidi Klum, Jada Smith, Emma Stone, Olivia Munn, well, Elsie. Elsie is not wearing the one from not wearing the Cavallari one, it seems. Elsie is wearing the is wearing the other one. I love the Elsie flex. How many pictures is it for a flex? Like were these two enough of a flex or do we just need a bit more? I feel like more flexing. You guys let me know what you think. Somebody tell Salty that Amber Heard is maybe not who they want to contain in the lawsuit. All right, wait, is there more law? Okay. I kind of love the Lauren Conrad shade. Well-known entertainers and notable people of influence have routinely been photographed wearing and featuring plaintiff's diamond dagger cuff jewelry to red carpet press and award events, including Scarlett Johansson and Amber Heard. Defendant Kristin Cavallari is a reality television personality who uses her celebrity image to market and sell her lines of merchandise, including Uncommon James, the Uncommon James brand of jewelry. On information and belief, defendant Uncommon James sells mass-produced items online and in retail stores, including retail stores in the city and county of Los Angeles. Upon information and belief, defendant Cavallari and Uncommon James jewelry is so poorly made, yikes, is so poorly made that they have earned an unenviable 2-star rating on Yelp.com from its customers complaining of the unacceptable quality of their jewelry and customer service provided at their Los Angeles location. Here's why this matters. There's a trademark dilution claim, just like there was in the Satan Shoes case, meaning somebody using a knockoff and that knockoff being of poor quality can reduce the value of the trademarked good because the two get confused. So that's a very, very basic recitation. But I love that there's links. Should we click the link? Let's click the link. Let's see. Is this for an unenviable 2-star rating? Is this for the jewelry? I guess we're not going to read the whole thing. No, we're not signing into Yelp. All I can say is I've shopped around a lot and I can't find a band to match the engagement ring my husband's gotten for me. Well, that's not their problem. Oh, this is for other jewelry nearby. Wait, we need these. We need these. We need these reviews, not other reviews. Where are these reviews? Well, I can put the link in the chat if you guys want to go read it. I'm giving them an extra star because one associate was nice. I love the brand and supporting small business owned by a woman. But if that's the type of woman you hire, I need to rethink purchasing pieces. Had the worst experience. Purchased a winter mystery item online. Loved it. So I went back to purchase more, thinking they would be different items every time. They're the exact same necklaces. Waste of money. I do not recommend Uncommon James. They definitely have a lot of not great reviews and some good ones. All right, we're not going to go down the rabbit hole. That is not currently recommended. One other review that is not currently recommended. Why is it not recommended? Huh. These reviews are not factored in. Huh. All right. Unhappy with customer service. We're not going to go down. Sorry, me going down a rabbit hole. We're not going down a rabbit hole of Yelp's Uncommon James Los Angeles location. But the reason it matters is for the trademark dilution claim. On or about January 24th, 2021, plaintiff Katz visited a retail store in Chicago that sold Uncommon James jewelry to in-store customers. At that time, plaintiff became aware that defendants, individually and acting together, had been selling jewelry under the Uncommon James brand that are identical or substantially similar to plaintiff's protected and registered designs. Specifically, defendants in each of them were marketing and selling a bracelet called the Paradise Bracelet, which is identical or substantially similar to plaintiff's diamond dagger cuff. Additionally, defendants in each of them were marketing and selling a ring called the Sunset Ring, which is identical or substantially similar to the diamond dagger ring. Accordingly, defendants' Paradise Bracelet and Sunset Ring are infringing. All right, so here's the designs. Should I put up a poll to see if they look identical and or substantially similar? So here's plaintiff's with her name stamped in. And here's Cavallari's. The bars holding them open are in different spots. But should I put up a poll? I should. I should put up a poll. Let's put up a poll. and see. Let's put up a poll and see what we think about to see if you guys think they are similar or substantially similar. Give me 1 second to get to my chat where I can put up a poll, and I'm going to leave this picture up while we do it. Let us. Now I've got to get over to my video so I can get to my chat so I can put it up once the chat populates. Which is going to take me a minute to get the live chat to populate on my video. I clicked on the wrong video again. This is like the third time I've done that, trying to put up a poll and clicking on the wrong thing. Emily, click the one you're actually live on. That's the only way you're going to get the live chat that you need. All right, so we can pop it out and put up a poll. We're going to let you play jury. Do they look the same to you? Yes or no? I'll leave that up till the end of the end of the stream. So you guys go vote. Tell me if they look the same to you. Maybe we'll put it up. We're court of public opinion. We're court of public opinion the designs and see what you think. So these are trademarked and copywritten. These are not. But it's like even down to the numbers of stones is what they are arguing, that they are the same. So let's continue on now that we've seen the pictures. And again, they're nice. You've got the background removed. So I'm interested to see what you think. Let us continue. Upon information and belief, defendants have misappropriated the designs and are selling infringing items online and in retail stores throughout the U.S., including but not limited to sales within this judicial district. Defendants are, without plaintiff's authorization, unlawfully reproducing, importing, distributing, or selling infringing items. Defendants' infringing use of the designs are not limited to the infringing items described above, but other pieces defendants created, manufactured, or caused to be distributed may also infringe on plaintiffs' intellectual property and designs. In or about March 2021, plaintiffs caused a letter to be delivered to defendants Cavallari and Uncommon James via USPS certified mail and addressed in Nashville, Tennessee. The letter expressed concern that the Uncommon James items seemed to resemble plaintiffs' designs too closely. The letter provided plaintiffs' contact information and requested that the recipient provide more information about the design of the infringing items. Upon information and belief, defendant Cavallari resides and does business at the address where the letter was sent. Upon information and belief, defendant Cavallari received the letter. Well, if it was certified, you would know if it was delivered. As of the time of the drafting of this complaint, defendants ignored, disregarded, or otherwise failed to respond to the letter. So they had a heads up and were like, So, upon information and belief, defendants continue to misappropriate the designs to unlawfully reproduce, import, or distribute the infringing items. In particular, plaintiff Katz visited the online catalog for Uncommon James on May 24th, 2021, and the catalog offered the infringing items for sale. I looked yesterday, they're still up there. As of the date of the drafting of this complaint, these websites are still active and the infringing items are still listed. Footnote 1, it's probably not sassy. It's probably just a link to the bracelet for $42. And then for, let's see, for the ring for $42. Are the ring and the bracelet the same price? Apparently so. Both $42. When you go to defendant Katz's website, though, which we'll pull up, you will see that this is it seems to me to be a signature design. And no. What did I type in wrong? I typed something in wrong. Because her website, plaintiff's website, has, excuse me, celebrity favorites. Oh, this is probably where the images from the lawsuit came from, is the things they had already shared where celebrities wore these to different events. But when you go look at the rings, a lot of the rings are that dagger style, but these are the ones with the diamonds are like $1,800. So there's definitely a difference in the cost. There's probably a difference in the materials used. They're probably solid materials and not plated, et cetera, et cetera. So these are trademark designs. So I know some of you in the chat are like, these seem like common designs. This design is trademarked. So no one objected to the trademark. So it's not so common that it wasn't trademarked, because the USPTO will tell you, no, it's too common to trademark. But there we go. So let us continue with this lawsuit and the $42 bracelet versus the $42 ring based versus the $1,800 ring. They say that, let's see, here's the first claim for trademark infringement. Again, we have a trademark in these things. You are making these things. You cannot. You cannot. On information and belief, Cavallari is aware that plaintiff is the registered trademark holder of the designs, which is part of why they flexed all of the people who wear the jewelry. It's like, this is jewelry that is worn in celebrity circles and seen. So that is part of, you would have been aware that this is trademarked. Also, a year ago, we told you this was trademarked. Let's see. Trademark infringement, defendants failed to obtain the consent or authorization of plaintiffs as the registered owner of the subject name and mark. And again, Cavallari and Uncommon James recently had a intellectual property dispute with a sunglass retailer. It's not like this is an unsophisticated defendant with an unsophisticated company. They've protected their intellectual property in lawsuits too. Intellectual property matters. So you can't just knock things off. This happens, it's harder in the makeup world because you can't trademark things the same way. So you get a lot of palettes that are dupes and look like knockoffs. But in jewelry and purses and clothing, you can absolutely trademark these things. And there's a whole bunch of trademark disputes going on with like Lululemon and Peloton right now over bra design and other things. So if we want to get it back into intellectual property, it's been a while. We've been in the defamation realm for a while, but if we want to get back into intellectual property, we can. These things matter. Trademark infringing defendants, they say, intentionally and knowingly used commerce to reproduce, counterfeit, or copy plaintiffs' registered design trademarks in connection with the sale, offering, and distribution. Trademark infringing defendants reproducing. Well, the rings, I mean, is that a knockoff? Is it a cheaper dupe of the plaintiff's ring? Because to me, it looks really close. I mean, it's not going to matter. Like, the angle of this is more open and the angle of this is more closed. It is the arrow with the two bands that are the thing. So let us continue to go on. That was the trademark infringement. Federal copyright infringement. Again, these are registered copyrights. So they're registered trademarks and they're registered copyrights. So there we go. Suing under both causes of action, and that defendants willfully copied the products. Dilution and tarnishment. This is what we were talking about with, like, hey, they've also got a 1-star rating. People are unhappy, and that can reduce the value of the mark. I love seeing the chat saying a cheater brand. A cheater brand. Maybe not a whole brand, but just the design. Plaintiff Dagger style and Rachel Katz's jewelry designs are famous within the meaning of the act, which again is part of why they indicated all the people who had worn this jewelry to show that this is a well-known piece of jewelry and a well-known mark, because they're going to have to prove that, and that they are distinctive in the state in which the trademark registration was obtained by virtue of a substantially inherent and acquired distinctiveness of the mark, which means the trademark, the USPTO said, yes, this is distinctive enough to be trademarked. It is not so common. It's not a single gold band. You can't just look, it's a ring. You can't just trademark that. It is just a single gold thing. You cannot trademark. It is too basic, but this was distinctive enough to trademark. They say that upon information and belief, the unlawful conduct of defendants Cavallari and Uncommon James began long after plaintiff's designs became famous, and that the tarnishment defendants acted knowingly, deliberately, and willfully with the intent to trade on the reputation of plaintiffs and their designs to dilute the value of plaintiffs' property. Because if you can get one for $42, why not? Tarnishment defendants' actions complained of herein are likely to injure the business reputation of plaintiffs, that the intentional sale of imitation jewelry items bearing plaintiffs' designs are likely to cause confusion, mistake, or deceive, mislead, betray, or defraud customers, and believing that the substandard imitations are genuine Rachel Katz jewelry pieces. Again, back to the arguments made in Aldi versus or M&S versus Aldi over the Caterpillar cakes. The argument was, look, people look at these cakes and think they're the same. So if you get the Aldi one and it's not as good as the M&S one, are people like, oh, this M&S cake is crap because you can't tell the difference? That's part of trademark dilution. It damages the brand if somebody gets something they think is the original, it's not the original, and then it's not as good. And they're like, well, I'm pissed at that brand. It's not as good. Part of the argument made in the Satan Shoes case as well. Tarnishment defendants' unauthorized and counterfeit use of the famous designs has diluted and will continue to dilute and tarnish plaintiffs' name and value of their property and detract from the distinctiveness of the designs. Right? If you have a whole bunch of rings out here that look the same, it dilutes the trademark. Part of having a trademark is having to defend it. Tarnishment defendants' conduct was intended to trade on plaintiffs' reputation and goodwill. Tarnishment defendants willfully continue to use the designs as well. Willful and continued use of the designs constitutes intentional infringement of plaintiffs' common law trademarks in violation of law, as well as dilution and injury to business reputations, violation of more law. Plaintiffs have no adequate remedy at law to compensate them fully for the damages that have been caused and will continue to be caused by the tarnishment, because again, you have to stop the counterfeit thing from being distributed. Fourth claim for relief: unfair, unlawful, fraudulent business practices against defendants. Plaintiffs incorporates the above, saying that defendants have committed all of the aforesaid acts of infringement deliberately, willfully, maliciously, and oppressively. Part of what they're going to go to in saying that is, hey, we notified them a year ago, and over a year they didn't rectify the action, they didn't let us know, so we notified them a year ago. You are doing this, stop it. And they ignored it. These are the allegations. They ignored it and continued on. Well, you ignored it and continued on selling these things. They're still on your website, even though you know. So that is the willful, malicious continuing of the behavior. It's why notice was sent. So that if they needed to sue, well, if it stopped there without a lawsuit. But if they needed to sue, then they would be here. Unlawful Business Defendants Act and practices as detailed above. Under California Business and Professions Code Section 17200 et sec, the unlawful business defendant's conduct constitutes unfair, unlawful, and harmful to plaintiffs. Plaintiffs are persons within the meanings of B&P. Plaintiffs are informed and believed that the unlawful business defendants have violated statutes and public policies. So, they're infringing on the marks. They shouldn't be infringing on the marks. Plaintiffs are informed and believe that there are no adequate remedies. You have to stop them from infringing on the marks. Fifth claim for relief: unjust enrichment, constructive trust, meaning that they are converting monies that would have potentially gone to plaintiff to purchase the items by selling counterfeit and or knockoff items. By virtue of the egregious and illegal acts as described above, the unjust enriched defendants have unjustly enriched in an amount to be proven at trial after discovery. How much have you sold this for? How many of these have you sold? That money is money you shouldn't have, because you shouldn't be selling our designs. Defendants' retention of monies gained through its deceptive business practices, infringements, and acts of counterfeit and otherwise would serve to unjustly enrich defendants and would be contrary to the interest of justice. I am just struggling at the end of the stream today to make words happen. California Civil Code 2223 and 2224 provide that a constructive trust is created where a defendant takes another's property, the designs, by fraud or any other wrongful act. Accordingly, plaintiffs pray for an order of this court imposing trustee status on the unjustly enriched defendants, meaning they're now holding the money till the dispute is done and then they have to give it back. if they win, so that defendants may not benefit from their unlawful holding of plaintiff's property. So the monies that they got and the designs and whatever gets held and like frozen so that they're not spending it and using it, because then if it's determined it needs to go back to plaintiff, it does. We talked about constructive trust a bit in the Brad and Angelina Winery lawsuit too. Plaintiffs are informed and believe that there are no adequate remedies. Prayer for relief. See, short, sweet pictures. We loves it. We loves a crisp lawsuit. Plaintiffs pray for judgment against defendants as follows. First cause of action for cost of suit, attorney's fees, damages, treble damages, destruction of the infringing items. You can no longer sell them. They must be destroyed. Destroy them. Destruction, disgorgement of profits. Give us back the money you made for it. Injunctive relief. Stop it. Don't do that again. You cannot. Heretofore, you may not infringe. Second cause of action for copyright infringement. Injunctive relief. Stop it. Impounding and disposition of infringing articles, same, take away. You cannot sell those anymore. Attorney's fees, cost of suit for other remedies. Third cause of action, damages and amount to be proven at trial for dilution. Injunctive relief, stop it. Attorney's fees, cost of suit, and other relief. Fourth cause of action, unfair business practices, restitution, injunctive and other relief, disgorgement of profits. Give us back the money you made selling our shit or selling, quote, knockoffs of our shit. For all costs of the suit and other. Fifth cause of action, for an order of the court requiring that defendants provide complete accountings for equitable relief, including that defendants disgorge and return or pay their ill-gotten gains obtained from the illegal transactions entered into and or pay restitutions, including an amount of monies that should have been paid if defendant had complied with their legal obligations. Meaning, if you had just licensed it to sell, if you had done a like Uncommon Jane's X Cat licensing deal to sell a version of it, then you would have had to pay for those rights to do that, which again, Cavallari and her business knows because they just resolved last year a lawsuit with an eyeglass company over licensing agreements and how licensing agreements were going to be done. This is not something that is completely unknown to them. For an order from the court that an asset freeze or constructive trust be imposed over all monies and profits, for damages and amount to be proven at trial, for plaintiffs and reasonable alternatives fees, all costs, etc. Signed by Salts Things. So, with that, we have a intellectual property case dealing with jewelry, expensive jewelry versus less expensive jewelry, and a reality television star host or personality. So, we're going to keep following it. I'm interested to see what happens. This was just filed yesterday. I mean, Cavallari might not have even been served with this yet because it was literally just filed yesterday. But could it settle out of court? Very, very really it could. But again, when you get the letter giving you notice a year ago of infringement, don't you just deal with it then? Do you really wait to see if people are serious? I guess maybe, but it's like, deal with it then. You know that you can't copy other people's designs. You can't use other people's trademarked rights. You know that licensing is an option that's available to you. Like, these things are known. Let's get to question. I have questions. You have questions. We have questions. We have lots of questions. Let's just get to questions. And then I'm going to go through the super chats that I haven't gotten to. Thank you, Lawnards, for hanging with me. A huge thank you, as always, as I'm talking over my swoop. We're swooping again. We're going to stop talking during ours. A huge thank you, as always, to our moderators for keeping the chat an amazing community to be. It's intellectual property matters. If you get something trademarked, you have to defend it. And that's what it is. So some people don't agree. Some people are like, look, it's a free-for-all. Who cares about intellectual property? Let's just let it be. But that dilutes from creativity, really. And that's why copyrights and trademarks were started, to protect amounts of creativity. So with that, we need to talk about COPO, because with COPO, I forgot to post it on social because I felt terrible. So I'm going to post it and we'll rule on COPO on Friday. So apologies with that. That was me. Julia asked what the poll said. Let me go close the poll. If you haven't voted, vote. If you haven't liked and subscribed, do that. Let me go close the poll and see what it said. The end of the poll will scroll. Let me pop out the chat and see. The poll said, do these look the same to you? Yes, 78%, no, 21%. So there we go. That's what the poll said. Thank you, Julia, for asking. Call me out. Question, are you feeling better now? A little bit. Still very congested, which I hate. I hate being congested. I'm going to get to some of the super chats that I missed while I was, covering the legal things. And then we will get to some more questions. So thank you all for your support and support of the channel. Even when YouTube hates me for talking about the things, we're an educational channel here. Let's see. Somebody asked about filings in the Kavanaugh-Klein case. I have not looked at the Kavanaugh-Klein case in in a few weeks. If there are filings, which would probably be Klein's response or an anti-slap, I'll cover them on Friday. So I'll go look and cover them on Friday. So we will do that. Candy's recovery, the mods probably blocked it because we don't promote in the chat. So that's why. We don't promote in the chat. So the mods probably just went, nope, that's against the chat rules. So no worries if you didn't know. Now you know. What you don't know if you don't know. But now you know. And that's what keeps our chat just a chat and from getting spammed with channels. So question, will you talk about Jeff's friend rolling up to Ethan's house? I did not see what happened. So DM me a link if it was talked about. Rolling up to somebody's house in a threatening manner is never good. I don't know what happened though, but somebody, I know there was back and forth between Whittick and Ethan. Here's as somebody saw on the YouTubes, if someone does not know me personally, has not been invited to my house, if you rolled up on my house, it would feel like a mind your business. I know where you live. That would feel uncomfortable to me. It's hard in LA, but I wouldn't love that. So I haven't seen all of it. Send it to me. I will look. Again, I've been kind of down and out this weekend. So that's because I've been sick. Let's get to some of the super chats that I missed, and I will continue to get to your questions. Feel free to ask them about these cases that we covered today. What's happening next? I will make a note to go pull Klein Kavanaugh stuff. And if Ethan has addressed it, I will go look for that too. So Carla said, this is a common design. None of them created this. Carla, I appreciate the super chat. I understand, but there is a trademark for it. And if there is a trademark for it, then the trademark owner has the right to it. So even if it wasn't, an original and no one objected to it, it's owned by the trademark holder and they're allowed to block it. So that's, even if it feels like, well, that's not that unique, they own the trademark in it. And, or at least that's what they're alleging, that they own the trademark in it. So let us see. Tamarine said, yay, I finally caught a live. Welcome. I'm sorry I wasn't able to pull it up. Appalachian Girl Design said, can I make you a crochet doll? And you're sure. You can always send stuff to me. My PO box is down in the description. I've gotten one from Alana down here, and my Alana goodies end up in here. I've got an unboxing I need to do of stuff that I got. So I definitely need to do that for sure. So yes, my mailing address is always down in the description down here. So let's see. Sister Babylon said, wait, why would Dell 1 be automatically entered on an HP computer? Sus. It's not automatically entered. They're saying that somebody used it as the username, and that's why it was being argued over in court, whether the _1 username could be populated or not. So that was part of that. Let's see what else. Question, will you be covering the Tinder swindler suit? I just addressed this on Twitter and asked if people wanted me to address it. So I have not watched the Tinder swindler. It's on my list for this week to watch it and pull. The lawsuit, the family he claimed to be part of are now suing him as he defrauded many women and companies affiliating himself with them. So I'm going to watch it and pull the lawsuit. Yes, I'll be covering it. Again, fascinating. So that is what it is. Let's see. That's what I see a number of you asking about the Tinder swindler. So that's what it is. Question, does she have to defend the trademark? Yes. If you have a trademark and you don't defend it, you can lose it. This was really discussed pretty thoroughly in a Rihanna lawsuit over Fenty with her father because it is her last name and they were arguing over the Fenty trademarks and part of it was but you have to defend a trademark. If you don't, someone else can come along and be like, "Look, there's all these other knockoffs. They've never defended against it. Therefore, I can do what I'm doing." And that can work. Question, could Duggar's lawyers be setting up an ineffective assistance of counsel motion? No, because that is very bad for them. Ineffective assistance of counsel has very, very negative consequences for the lawyers. So no, that is never a strategy to set up. It's a great question, Heather. So I'm not like, no, no, no to your question. Your question is great. But trying to set up like, oh, well, we'll give you a back door to get out. Like we'll mess up so you have a back door can actually get them disbarred. So no, I don't think they are doing that. I think they are trying to make the motions that they can on the facts that they have, and their facts aren't great. The one that I am most interested about, if I don't sneeze, oh, we might sneeze. Apologies. The one I'm most interested to see is what happens with the EXIF data and the experts. That is what I'm very, very interested to see. So that's a great question, but no, attorneys should never be doing that. Question, what if the design was over 1,000 years old? Was the trademark on jewelry that long ago? No, trademarks tend to be newer, but when you file for a trademark, someone has to object and say, you can't trademark that. That's actually mine. And if no one objects, then you get the trademark and then you have to fight it out later. So if that is historical jewelry, then someone can own a trademark in it if it's not already otherwise protected by trademark or copyright. So thank you for joining the channel. Question, old friend, new name. Hello, wine is cheaper than therapy. Do you know if any of you law tubers will be covering the Johnny Depp Amber Heard suit? Surprise, none has been. There's going to be a pool camera in the courtroom. If there's going to be a pool camera in the courtroom, I will be covering some of it. And I will look at whether I will stream it or not. I have to get caught back up on what has gone on in that case. There is so much litigation that's gone on there that I will have to catch back up. But yes, I need to go and look at when it's going to start and then go from there. So if there's going to be a pool camera, pop culture, is my jam. So we will definitely be talking about it as it gets on to trial. So question, thoughts on Inventing Anna? I haven't seen it. So I don't know, but I can put it on the list. Please, please, if not already, model after the lock-picking lawyer and open packages P.O. box items at the post office parking lot. And they're not at home. He was sent a GPS tracker. Yikes. Well, that's wild. I never even thought about that. Or that somebody would do that. I mean, I guess with like Apple tags and stuff, it's pretty easy, but something to keep in mind. So I will go look at what the lock-picking lawyer has done and keep that in mind. So thank you. We're going to get to a few more questions. Do you have any plans to cover the Brian Flores NFL suit? I just haven't gotten to it yet. I don't know if I have a heavily NFL interested audience, but I just haven't gotten to it. It is on my list to look at. I have not read the lawsuit yet. So those are the things that I try to balance to cover all of the different things that we have to cover. All right. From the super chats, I want to say Raichu, but I know that's not right. Raichu, we're going to go with that. Apologies. My dog just laid down right next to my phone to listen to you. I've never seen him do that before. He must be invested in the law. I think so. I think that's the reasonable takeaway. Sister Babylon said, so the defense knew Williams was a nothing burger, so they didn't subpoena him, but now they have beef. They could have, and they said that they did subpoena him. And they could have done that investigation. They would have had access to that knowledge that that person existed through Josh Duggar saying, I know this person exists. But they did subpoena him and they said that he was not responsive to them. But that's also on them to then go to the court and say, this person hasn't responded to our subpoenas and do that. So they could have, and the court said, you can call this person. This is the foundation you have to lay before you can impeach them with a prior conviction, which is just legally proper. Question, can the sanctions against the oligarchs affect the sale that Angelina Jolie just did? So the sale happened not almost a year ago. The sale happened a while back. I would have to go look at the date. Let's just go do that together because I've gotten asked this a lot. I have not looked at the details of all of the sanctions to know whether the company that it was sold to, let me pull it up, whether the company it was sold to is part of the sanctioned companies. I do not know. If they are part of the sanctioned companies, then yes, it can impact it, but that shouldn't legally change what the court in California decides to do. So I'm going to pull that lawsuit up real quick and just pull it up on screen and go through because I did get that question quite a lot. And again, once they say Russian oligarch, though I have not, there is apparently, I have been told, there is another suit going on with the new owners of Jolie's company between them and Brad Pitt that I haven't pulled yet. So there is more to parse with this lawsuit because there are other parts of it that I am not and have not gotten into yet. So let's see when this alleged sale happened. Pitt develops it. Let's see. December 13th. Oh, by the way, we learned that Mongo Bongo from the chat, you're amazing, and from the comment section, you're amazing. Mondo Bongo is the song from that dance scene in Mr. and Mrs. Smith. I shared it on Twitter. Mondo Bongo. Anyway, that's what it was from. And I thought it might be, but I was like, no, Emily, that's dumb. And then multiple people commented on it. I'm like, no, I'm going to go pull it up. It is. It's the unofficial title of that song. So we know what the Mondo Bongo is about, which seems kind of sweet, but it depends on how you feel about the parties. We're not talking about how we feel about the parties. All right, let us find this date real quick. Yes, it flourished in September 2016. Divorce proceedings, yes. Sells her interest to a Russian oligarch. Okay, when did it sell? In 2019, Pitt and Jolie were in buyout discussions. January 2021, they said that they were breaking off discussions. June 15th, 2021, they were breaking off discussions. Let's see. The HROs no longer applied in September. The press release was October 5th. So this happened less like 6 months ago, I guess, in October of 2021 that it was sold or thereabouts, that it was sold between September 8th and October 15th, that the sale was made final for Tentu Del Mondo is the company. So I don't know if that company is under those, but it is the Stoli Group's company. So if that group is affected, then yes, it will be affected. If that group is not affected, then no. Question, is the amount of cases you are following at the moment ever reach the amount of cases you handled simultaneously while you were a prosecutor? No. I'm following way less cases than I handled as a prosecutor. And as a prosecutor, my brain was always full and busy. But this is the amount of cases that we're actively tracking here is less than what I covered there. How did you handle that? Not well, with a lot of burnout and a lot of notebooks and trying to not let things slip through the cracks. It was always quite a juggling act. Always a juggling act. That was the question I wanted to get to. Let me see what else we have from Super Chats. Jay Thompson said, come on, we need to hit 200K. She's so damn close. We are so close. So close. All right. And that is the end of the Super Chats that I have pulled up at the back end. So we will get to a few more questions. Thoughts on Jeff Wittick's new stance in regards to David Dobrik documentary Casey Neistat made? I have no idea that the documentary was made by Casey Neistat on David Dobrik. That'll be interesting. I didn't know Casey Dobrik, Jesus. I didn't know that Casey Neistat was doing like YouTube documentaries. I'll be interested to see. Was it Casey that called Jeff Wittick and was like, hey, this is what he said? And the only new stance I've seen, so there might be more, and I might just need to dive in and cover this on Friday again, because I talked about it a little bit on Friday. If you guys are interested, I will, just because I will cover it from the standpoint of, can there be a lawsuit here or not? But I still think there's time for Jeff Wittick to sue. All I saw was that Jeff was pissed because he thinks Dobrik is shifting the blame to him. But that is look, if um if Jeff Wittick was trying to avoid suing a friend, trying to keep a friend group together, trying not to damage someone, in a civil lawsuit because there had been agreements. If there had been an unofficial like handshake, you pay for the medical bills and we'll be fine, and then that has ceased, he still has time to sue. He needs to talk to a lawyer. And then things that will come up from Dobrik are like contributory negligence. Like, what did Wittick do? Did he undertake an unsafe condition? Like, it's not just no, Siri. It's not just an easy, um, hey, you got injured, therefore it's this, but it is a back and forth. But a plaintiff's lawyer sitting down and talking to Jeff Wittick can explore all that with him and decide if he wants to go that route. He has to make that decision. And it's not an easy decision to make. It seems obvious to a lot of us, but it's not an easy decision to make, just going, go ahead and sue someone that you were friends with in a group that you worked with, or sue the company. But it doesn't look like David was operating under a company that would protect him in this way, from what I've seen publicly available. It doesn't mean there isn't more back there. Kelly Bella, this is a great question. How would someone know how they're supposed to argue against trademark that someone else has filed? There's notifications, and you would have to have somebody watching them to do that. So this is what trademark attorneys do, and companies will look at this when they are trying to protect their own marks. This is why an intellectual property attorney, when you are creating things, is important. So attorneys do that. There are attorneys that do that. So there are individuals can too. You have access to it, but it's much harder. Question, Frida said yes on the David and Jeff situation. Do you think I'm assuming Jeff, signed some form of document that prevents, Jeff from suing? He indicated in his own series, and I haven't watched it in quite a while, that they had never signed anything. So with that, they indicated that they hadn't signed anything. So question, are you going to look into the rare beauty lawsuit? I had no idea there was a rare beauty lawsuit. So I can't. We love a beauty lawsuit around here. Question, would you and Dr. B's version of buying a vineyard in France to retire and grow old in, where's your dream place to retire? I really love Middle Tennessee. I would love to have way more land in Middle Tennessee. I would love more space. I think we would be more animals than vineyard oriented. So, but I really do love Middle Tennessee. But I think one of the things about Middle Tennessee that I really like is the ability to go to beach houses and stuff. So we're looking forward to exploring the shore down in Alabama and Florida this year. That is something we're looking forward to. Question, did the court rule on the quash motion filed by Jen Shah last week? Not yet. I mean, not as of this morning when I pulled it, but let's go peek at Pacer and see if anything else has happened. Why not? Why not? We're already there. Let's see. Is this the Shah case? The Shah case. No, that's the Maxwell case, because there's nothing new in that either. I was looking for that too. Oh no, there is something new. We'll cover that on Friday. The government replied in the Maxwell case. Let's see. Let's pull this up. Mods are like, no, we're not going back to pulling up documents. Just real quick. Just real quick. In the Shah case. But no, as of this morning, they had not yet ruled on the motion to quash. But things are moving fast and they're getting ready. I mean, it's 1:30 here, so it's almost 2:30. They should be getting ready for that hearing now. And so hopefully we'll have an answer. And again, another plug for, if you don't follow me on social media, we're almost at 40,000 on Instagram. Since I spoke to you this morning, there are 3 new documents on Pacer. Since this stream started, there are 3 new documents in the Shah case while I've been live. Let's see. Notice of motion and oral argument requested. Document filed as to all. Well, let's just take a look. Hold on. I'm going to need to timestamp this in case anything happens. 222. All right, let's take a look. We're just going to look directly at the documents. Um, let's see. Oral argument requested. Please take note. Let me see if I can make this bigger for y'all. Docket and file. Please take note that upon the accompanying memorandum of law, declarations of Eileen Murphy, and supporting documents of non-party, ABC will move this court before the Honorable Sidney Stein at the district court, quashing a subpoena issued upon it by defendant Jen Shah. Oh, so ABC is being subpoenaed by Shah pursuant to the individual practice rules. ABC respectfully requests oral argument. So ABC would like to be heard to quash a subpoena, which begs the question, Jen Shah, what are you subpoenaing ABC for? ABC did the Hulu documentary, so I'm imagining it's that. Let me pull that up and let's see what happened real quick. This case is going to get real busy ahead of trial. Let's see. Uh, now I've got Mondo Bongo stuck in my head. Mondo Bongo. Let us keep going to questions. All right. And a huge thank you to the mods. Question. This is a good question while I'm pulling this up. Would David be deported if Jeff sued him? No. Civil lawsuits should not affect status. Criminal prosecutions can, but it doesn't seem that this is criminal in any way. A civil lawsuit shouldn't impact that at all. Could it affect his ability to further get citizenship? I would need to talk to an immigration attorney that dealt with that, but no, that should not cause loss of status. Let's see. This is a declaration and memorandum of law. So these are all motions filed by ABC. Let's just look at the declaration real quick because the declaration is going to tell us everything that's in the memorandum of law without getting into the law of it all. Oh, I hear a Ponard. Hi. I guess you're free. I guess work's done. You've been freed. Well, the law nerds were missing you. I'm glad we stayed live long enough for you to come in and say hello. All right. You can come say hello. Hi. Yes, you can just don't bump your head into the microphone though. You keep moving it with your tail. Ah. There we go. Now you're free. Hi. Yes, we're here. All right. Law nerds, paw nerds, unite. Let's see what this declaration says. Oh, I lost my train of thought completely. The declaration is going to tell us more about what is in the document. So the document will say this person said this, this, and this. And then the declaration is just going to give us their facts. So we're going to get to the story without all of the intervening law stuff, which for our purposes now, we just want to know what happened. So that's fantastic. Murphy, legal age, otherwise competent to testify, senior editorial producer for the documentary, bing, 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 about Jennifer Shah that became publicly available on Hulu on November 29th, 2021. Hello. Okay. I've got you. The documentary was produced by ABC News Studios, which is a division of ABC News that produces documentaries which are streamed and or aired on various platforms, including Hulu. I've produced documentaries about various topics for ABC News Studios, including America's Greatest Threat, Vladimir Putin, ISIS, The Rise of Terror, 24 Hours, an Assault on the Capitol, Inside North Korea, Live from the Games, and Mike Tyson, The Knockout. That's a wide variety of experience. I have worked as a journalist for almost 30 years, including as a producer for ABC News on programs such as Nightline, World News Tonight, and Good Morning America. From July 2021 through November 2021, I and a team of about 20 other journalists worked on developing and producing the documentary. The documentary itself also includes on-air reporting by Aaron Katzgry, who is an ABC News senior investigative reporter, and commentary by Chris Connolly, who covers popular culture for ABC News and also reports for ESPN. Fred, you just want to be here. I know you love the mic. Hi. You just want to be here. All right, you can just be here. During the course of the investigating and creating this documentary, my team and I reviewed numerous public court filings and interviewed dozens of sources. Some of those sources spoke on the record, and the documentary includes excerpts of interviews with almost 20 persons. More than a dozen other sources spoke on background, which means that they allowed us to use the information they gave us, but asked that their names be confidential and that they not be quoted directly. My team and I did not speak to any prosecutors involved in this case. A true and correct copy of the documentary is attached here too on a thumb drive, which is attached as Exhibit A. Have fun watching the Shah shocker, Your Honor. I love it. A true and correct copy of the documentary is attached here too. Okay. The subpoena served on ABC News. This is what I want to know. Ooh, attached as Exhibit B. We're going to get to see it. Yeah. Demands that ABC News produce a vast trove of documents, footage, and communications related to the documentary, including any documents related to the dozens of interviews conducted for the documentary. Investigating and producing a 48-minute documentary over the period of several months is a large journalistic project that generates thousands of documents and materials such as emails, text, drafts, pages, and notes, and digital media files. You can go up there. Complying with the subpoena would require me and my team to search for and disclose a large volume of unpublished information relating to the program, including unpublished footage and notes from dozens of interviews, including on background interviews, which sources should be protected. I believe that producing these records would have a negative effect on my career as a professional news producer and journalist, as well as others on my team and on ABC's news. Journalists routinely produce news and documentaries that pertain to current events, including pending criminal prosecutions. If sources are under the impression that I and other journalists could be forced to produce all of our work product about our conversations at any time, it would be very difficult, if not impossible, to effectively report on such matters. To ensure that ABC News is not seen to be an investigative arm for the prosecution or defense team, I believe it's important that the subpoena be quashed. I'm sure there's going to be legal beyond that. Hopefully there's a signed version of this, or this is just really poorly scanned. It's really hard to tell, but that might just be really poorly scanned because it looks like it just does not look like there's a signature, but there might be. Let's look at the subpoena. Exhibit A, physical thumb drive. Exhibit B, subpoena. Perfect. ABC News, you want to just sit on my lap? You can't. There's not enough room. He's like, there's enough room now, woman. I'm making their room on your lap. Fred's just done. He's just going to lap sit. That's what we're getting. Let's see. ABC News, U.S. versus Jen Shah. Attachment A. Let's see what you're looking for. Proof of service. This is very poorly scanned. Attachment A. Definitions. Defendant means Jen Shah. You and all those mean ABC. Program means the housewife and the Shah shocker. Prosecution team, agent, documents. We're not going through definitions. I just want to see what they're asking for. We'll deep dive into this if we need to on Friday. I'll also share it on social after this. So let's see. General instructions. Don't kick me. You are requested to produce all documents. Oh, geez. That's overbroad. Not narrowly tailored. That's not specific. That's very, very broad. All documents designated below which are in your possession, custody, control. You're requested to produce the original and all non-identical copies, including drafts of each document requested. Each request for documents herein and subparagraphs and subdivisions thereof shall be construed independently. Oh, man. If you claim any privilege, which they will, as a basis for not answering any requests or any portion thereof, or for withholding any otherwise responsive document, please set forth with respect to each document in specificity what you are essentially objecting to. Well, the type of document, its title and file reference, they're not going to tell you that. They're not going to disclose the title and file reference because that discloses information. The name, title, employer, and address of each person who drafted, revised, signed, or provided information for or received such document. No. If redacted documents are produced, the reason for the redactions. You are requested to produce all documents and items designated below via email. If said documents or others cannot be produced via email, send them. Requests for documents. All right. All video footage, including raw video footage made or used in conjunction with the program. This request includes, but is not limited to, any video footage that was not aired. So all the unaired stuff. Hi, buddy. All documents and communications between ABC and any member of the prosecution team. Well, they already said there wasn't any in their declaration. Identification of all government agents or other members of the prosecution team who provided information. Any and all releases, waivers, and other documentation provided to any individual who appeared in the program, literally everyone. All video footage concerning defendant Jen Shah filmed in preparation for the program. Any and all documentation and communications concerning the interviews taken for the program, including without limitation the interviewer notes taken either during the recorded portion of the program or during pre-interviews, internal memoranda related to the interviews, any and all documents and communications between you and any employee or representative of Forbes Productions, Intervent TV LLC, Bravo, or NBC Universal. That's broad. That's real broad. That's a real big reach. So they want literally they're like, give us everything. That's not going to happen. And they have I'm sure they're alleging their First Amendment freedom of press rights, but they are going to argue that they are protected. I'm sure New York has a shield law that protects reporters and journalists from having to disclose their sources, except for narrowly tailored exceptions. And generally, the person requesting the things have to prove the narrowly tailored exception in court. So I don't know how Jen Shah's lawyers are going to prove that they have to get all these things for trial. Oh my. They want quite a lot, don't they? That's going to be interesting. So I'll read their memorandum of law and we'll go over that on Friday. I'm very interested to see what comes out the rest of the day. It has been 2 hours and 34 minutes, so I am going to have to go. But we will see the judge rule probably on all of these together. But ABC's asking for oral argument like, hey, our news organization is not going to be protecting these. And I think one of the things that I have been talking about and we'll talk about more is where the freedom of the press lies. We've seen a number of like defamation suits against the press, and now we're going to see the press pushing back on not disclosing their sources and information because a free press is part of our First Amendment rights. And it will be very interesting to see how this parses and what Jen Shah's attorneys argue for literally all of the production notes. They've already disclosed we had no communication to the prosecution team. And if that's the heart of what Shah's lawyers want, they answered it in that declaration. And I imagine it's in the motion. So we did not go over the motion. I'll take a look at that motion to quash. I'm sure they're asserting shield laws, et cetera, in that. And yeah, we will be getting to that on Friday a bit more. I will be sharing it on social. Huge thank you to the mods. If you don't follow me on the socials at the Emily D. Baker, go do that. I will be sharing this there. And I will be sharing an update on when this trial will be because that hearing should be going on in New York now. And there should be a minute order later today telling us what was decided and if this trial was put over. There's going to be a lot of litigation to happen with the motions in limine and all these motions to quash. The court has a lot to do that they're probably not going to do between now and March 22nd. This is going to get put over, I think. So we'll find out what happens later today. I appreciate being here with you. Thank you for being a law nerd. Thank you for supporting me and the channel. Fred's going to say goodbye. Fred, do you want to say goodbye? Fred's looking at me like, nope, I want to watch the birds run around outside. All right, Fred's going to watch the birds outside. I'm going to say goodbye. Thank you for being here. Thank you for being a law nerd. I will see you soon. This was a lot today, but hey, come on, ABC, with the new filings today. Glad we got to cover it. I'll talk to you soon.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.